Okay, you can give me about 5
Brownstown
minutes.
Square versus Clarence Tucker. Brownstown Square versus Clarence Benson Tucker, 2601332.
Good morning, Your Honor. Attorney Elizabeth Ellison, PA 2098 for the plaintiff.
Good morning. Your name, sir?
Clarence Tucker.
All right. Counsel?
Your Honor, this is his motion to set aside the default judgment. We did attempt to discuss, but we have no resolution, Your Honor.
Yeah. What, you filed a motion to set aside the judgment. And you say see attached. What's your good cause? Why weren't you here?
Yes, Your Honor. I had back surgery.
What day? What day?
It was on it's April 28th, but it was first scheduled for April 21st. And I have a letter tank showing that. And so then
I signed the judgment April 24th.
yes.
I'm asking you why you didn't appear. Why weren't you here? Did you call the court, say, hey, listen, I've got a problem. I need an adjournment. Did you file a motion to adjourn? Why weren't you here?
I wasn't here
Your Honor,
because of the
Yeah.
if I may, it doesn't look, and I apologize, I was in a breakout room checking someone in, but I don't show we ever had a court date on this. It was a default failure to answer.
I see.
And now
I'm
he's
sorry. I
filed the
just
motion.
got back in town last night and I'm sorry. I'm a little out of sorts this morning.
That is correct, Your Honor. It looks like it was a default some certain for failure to answer the complaint.
What day was the service process effectuated?
Your Honor, the proof of service says it was served.
April 1st, I believe.
April 1st?
Yes, Your Honor.
All right. And the complaint, the civil complaint filed in this case was for past due rent. Is that right, counsel? Ms. Ellis?
Your Honor, this is this post-move out security deposit dispute.
Right.
It actually stems from, there was a fire in 2024 in his kitchen due to, I think, a cup on the stove when he fell asleep. At that time, he woke up, put it out, but he asked my client not to call the fire department and that he would, and they entered into a side agreement where he would pay $1,800 for them to repair it over, life at $300 a month, but they ended up adjusting that. And so he made those payments until a little before he moved out. And he has signed that agreement with them that he would pay that until it's satisfied. And now I guess he talked to his sister, who's a lawyer in another state, and decides he wants to fight the charges. But in our complaint itself, Your Honor, we attached the agreement. We attached the photos of the move out photos because some is, it generally just stems from the way he left the unit, as well as the remainder of that agreement, which is also attached to the complaint.
What else would you like to say?
yes, Your Honor. I've been living at this apartment for 10 years. I retired in 2022, and but I was living there prior since 2015, and I never had an incident like this. But after I had a car accident, I had a hard time getting around. And that last surgery, I had a number of surgeries, but this last one was on my back. And I just want to say that particular evening, I had a cut board cutting up onions on the stove. I had a flat cut board, and I made spaghetti, and then I put everything up, and I left the cupboard on the stove. And that evening when I went to go to bed, the only thing I can think of is that maybe my hip must have swiped, went against that side of the stove that turned one of the knobs on. And then I went to bed, and then I woke up to the fire alarm, and immediately went to the kitchen and put the fire on top of the stove out. The thing that was on fire was a cupboard. It was a plastic cupboard. I put it out with water, and the only thing I can see that was damaged was the fan above the stove, and so I was thanking God it was a minor fire that I caught it in time, and I stayed up for some hours to just making sure that everything that there was nothing, that the fire, everything was completely out. And then I called the management the next morning to let them know what happened about this accidental fire. And they all came over.
Give me 1 second.
Oh, just
Yeah. Go ahead.
and they all came over, and I let them know what happened. And during this time, I noticed that the apartments around me were all being remodeled. And I had one of the older apartments. Well, they told me that they gave me an ultimatum. They said, hey, you're gonna have to move, because we're gonna call the fire department. And I said, I have no physical way able to move, and or in no position to move. And then they said, well, if we called, they asked me if I had renter's insurance. I told them I did. And then they told me, hey,
I don't know why you wouldn't be responsible for the damage. Okay, let me just stop you. Just let me stop you. I don't know why you would not be responsible for the damage. Just let me finish. I can't imagine a scenario based on what you've said so far where you're not going to be held responsible for the damage. It's a small amount of money. That being said, if you want, I'll set aside the default judgment, but it's going to be conditioned upon you paying costs to them in the amount of $150 within 7 days. So if you want me to do that, I'll do that for you. I really have a hard time finding good cause. There's a lack of meritorious defenses here. I mean,
well, the thing is,
sir,
I'm sorry.
I'll go ahead and order that. I'm going to set aside the default judgment conditioned upon defendant paying costs in the amount of $150 to the plaintiff on or before June the 22nd. And defendant will have then until, once paid, defendant will have until July, I believe, is the 4th on a Saturday.
It is, Your Honor. We're closed.
So
on the
you'll
3rd.
have until July 6th to file an answer to complaint and affirmative defenses. So again, will you prepare that order for me, Ms. Ellison, please?
Absolutely, Your Honor. I just want to make it clear to him, if he doesn't pay that $150 by June 22nd, the default stands.
That clear to him. If you don't pay it by June the 22nd, then the default judgment will remain in full force and effect. Do you understand that?
I'm trying to understand. I'm paying $100 because I already paid monies already.
Sure.
And I'm trying to.
Sure.
I'm not sure.
You should have answered the complaint. I have a hard time finding good cause, and I'm not sure there's a meritorious defense at all. You want to argue this with him? That's fine. I'm going to go out of my way and somehow, some way, justify and rationalize in my brain why you didn't answer the complaint. and find that good cause exists, but you're going to pay them costs. So I'll set aside the default judgment conditioned upon you paying costs to the plaintiff in the amount of $150. So you'll have to make out a check to Brownstown Square Apartments, and it has to be received by their lawyers on or before June the 22nd. Do you understand that?
Yes, yes.
And then,
Do I pay anything beyond that or
we're then going to start over. We're going to have the case heard. That's what I'm trying to tell you. It doesn't sound like you have a defense. Okay? Listen very carefully. Sounds like they're entitled to judge. I'll let you go out and argue all these things if you want. But you didn't do what you were supposed to do when you were supposed to do it. So no, this will not apply toward any balance. It's for having them have to appear in court, file their, or first of all, prepare their default judgment, and then to come to court today and respond to this motion. Do you understand what I'm saying to you now?
I
You might not
understand,
like it.
I understand, sir, and I don't have an attorney representing me, but there is, I was going by the Sutton rule.
Let's stop the suck. I don't want to hear any of this. I'm telling you what my order is, okay? I should not be, could I be more clear with you? I shouldn't even be setting aside the default judgment. You should have answered the complaint when you were supposed to answer the complaint. You didn't. And I'm having a hard time finding good cause, and I'm having a hard time finding a meritorious defense. I'll go ahead and set aside the default judgment. It's conditioned upon you paying $150 in costs to Brownstown Square Apartments on or before June 22nd. If you don't make that payment to them on or before June 22nd, then the default judgment will remain in full force and effect. If you make the payment and you have until July the 6th to answer the complaint and file affirmative defenses.
Oh, I understand.
Okay?
Yes, sir. Yes, Your
And I'm trying to tell you this nicely because maybe, just maybe, you should go back into a breakout room right now and talk to Ms. Ellison and see if you can't resolve it. It'll save you $150 in the long run, plus whatever you can negotiate.
I understand, Your Honor.
Do you? I want to make sure.
Yes, Your Honor. That car accident I had, it really.
Okay, that's fair, but I'm just telling you, you have to pay $150, and that isn't going to apply to any balance owed.
I understand.
And then if you do that, you must file the answer to complaint and affirmative defenses by July 6th, okay?
Oh, I understand, Your Honor.
Will you send that over here today, please, Ms. Ellison?
Absolutely, Your Honor. Right after this hearing, I'll draft it up and
Good
give it
enough.
to you.
Good luck to you, sir.
Thank you, Your Honor.
Thank
Thank you,
you.
Your Honor.
Midland Credit versus John Rennie, 2601395.
Good morning, Your Honor. Matthew Kuipers on behalf of the plaintiff, P71348.
Good morning, Your Honor. Jocelyn Nguyen on behalf of the defendant, P64890. I apologize
Yeah,
if my camera is not.
Well, I need you to have your camera working. I don't want to really do these without seeing somebody at least. Where are you?
Your Honor, I'm stuck in the Philippines right now on a remote island, and the Zoom isn't letting my camera connect for some reason.
Let me ask you a question. Are you out of Las Vegas, your firm, or what?
My office is out of Las Vegas, but my mother isn't doing well right now, so I'm currently in the Philippines seeing her.
Well, I'm going to adjourn this a week. I'm not sure this Zoom is such a good idea anymore. You know that? I can just tell you. You have a preach.
Your Honor, if I could, this matter is resolved. We need to resend a consent judgment to defense counsel so that it can get signed and by the defendant, and then it'll be resolved. So we're just asking for an adjournment, maybe 2 weeks to get that done.
All right, we'll adjourn it 2 weeks, okay? And I hope everything works out for your mother. But we got actually people zooming from outside the country now. My God, where are we going with this crazy profession? Give me a date, if you would, Jennifer. June the 29th at 8:30. Is that good?
The 8:30. Yes, that'll be fine.
All right, I'll adjourn it June 29th at 8:30. Thank you. Good luck, counsel. With your mother,
Thank
I really do wish her well. Owners Management versus Skelly Woolworth, 2601718.
Morning, Your Honor. David Lechner on behalf of Owners Management.
Ma'am, your name?
Kelly Woolworth.
What are we doing with this one now?
We have a conditional dismissal, Your Honor.
Okay, do you care to put the terms on the record?
Yes, thank you. We've been speaking for a while now. Last time we were in court, I relayed an offer to Miss Woolworth, and she accepted it today to avoid the trial on June 29th. That offer is that in return for our dismissing the case upon the court signing the conditional dismissal, Miss Woolworth will move from the unit in question on or before July 15th, provide keys to management on or before July 15th, and dismissal will stay off her record. I explained MCR 4.201J to her since she is unrepresented. I also asked her for permission to sign her name to the document. She gave that to me. I also explained to her that I'd be checking paragraph 4B, that if she doesn't move out on her, if she's not in compliance with the conditional dismissal and plaintiff instructs me to reopen the case, I will file a affidavit and all other proper pleadings, and a judgment would be entered against her at that time. After explaining all that to her, she agreed to the terms of the conditional dismissal. Is that correct, Ms. Woolworth?
Yes, that is correct.
So you understand you have to vacate the property on or before July 15th. If you do not do that, he's going to submit an affidavit of noncompliance, a judgment will enter, and a writ will issue. Do you understand that?
I do understand, Your
And
Honor.
again, you agree to those terms?
I do.
Since you're unrepresented by a lawyer, you have 3 business days to clean and fill out a motion to set aside the judgment. You have 10 days to appeal this. Do you understand that?
Yes, sir.
Any questions?
No, Your Honor.
Okay. I wish you well, ma'am. And he has your permission to sign your name to that proposed conditional dismissal?
Yes, he does.
All right. I wish you well. Good luck to you. Thank you.
Thank you.
Thank you, Your Honor.
All right. Crown Asset Management versus Aaron Miller. Are we ready on that?
We are, Your Honor.
This is 2601280. Mr. Venkstein, your name?
Michael Bankstein, P69778, on behalf of Crown Asset Management.
Miller, your name?
Aaron Miller.
All right. What do you have to say, counsel?
Okay, thank you. In answer to your previous question, I did look at the credit card account agreement, and I know that the court has a copy of that as well. It was attached to the complaint. Did you want me to wait until you got to that spot so you could see it as well?
What paragraph is it?
It's paragraph 8 of the credit card account agreement. I think the page sequentially in the complaint itself should be somewhere around page 19 of the summons and complaint, but it might be in a slightly different order. But it's towards the back. We have a bunch of statements that show all the purchases and payments by a defendant and that it was mailed to her. And then past that's the chain of title. And then past that is the credit card account agreement. But it's page 8 of that credit card agreement.
Location and costs?
Location and costs, yes. My reading of that paragraph is that if it goes to arbitration and defendant wins, then we'll pay her cost. That's my interpretation of it. But I do believe that there would be some cost associated with defendant initially, starting the arbitration. That's my reading of paragraph 8.
May I?
Well, I think all I have to do at this point is go ahead and indicate defendant's motion for arbitration is granted. and this case is dismissed without prejudice for the reason that the parties are going to submit to binding arbitration. So at that, unless somebody can tell me why that isn't right, I'll go ahead and that's my order.
Your Honor, typically, I haven't done a ton of these, but typically most courts in this situation have actually given defendant a particular period of time, either 30 or 60 days to initiate arbitration. And, you know, if the arbitration is initiated, then it goes to arbitration. But if the arbitration is not initiated, then the matter is abandoned.
Why does it say the defendants initiate the arbitration? Where does it say that in here?
Let me see. I'm just telling you how most courts have done that.
I don't care how most courts do it. I want to do the right thing. If
Okay,
most
fair
courts do
enough.
that
If you
and
go
they're
to
wrong, then I'm not
fair-
going to follow
fair-
what they do.
Fair enough. Go to the page previous to the page you were looking at, starting an arbitration. Arbitration may be elected by any party with respect to the claim.
Wait a minute, slow down. You got to tell me where you are.
Sure, the previous page from where we were. So just go up one page. You'll see paragraph 4. Are you seeing paragraph 4?
Hang on one second.
Okay.
Be sworn.
Raise your right hand. You solemnly swear to put your testimony about what the next word is issued, the whole truth, let the truth. Name, spelling, name, career.
Grady, EMBERGRADY.
Thank you. You may inquire.
Thank you.
Honor, I apologize. I forgot to make a sequestration motion.
And I would have an objection to that.
Okay, yeah, any witnesses that are going to testify are hereby ordered sequestered from the courtroom and not to discuss any testimony that they may be giving.
May I request an exception from my officer in charge?
The officer in charge may remain in the courtroom.
Thank you.
Thank you.
All right, go ahead.
Good morning, ma'am. How are you doing? Doing just fine. Thank you for asking. Ma'am, how are you employed?
Senior paramedic at Huron Valley.
How long have you worked for Huron Valley?
Since July 2019.
Were you working in the same capacity on or about May 25th of 2025?
Yes, sir.
And were you specifically on shift that day? What shift were you working?
Regular.
What shift is that?
Fine. Was 7:30 p.m. 7:30 a.m.
So you were on shift 7:30 p.m. the before the 24th, is that correct?
Yeah.
All right.
Actually,
No problem. Specifically in the early morning hours of May 25th, 2025, were you ever on I-94 at West 12? Why were you there?
purpose of fiance goes to another call in Belleville. We needed to take that for you.
When you say we, who's we?
My partner,
What's your partner's name?
Alex Shankowski.
While you were en route to that call, did anything happen that caused you to stop on I-94?
I guess we spotted a man who is new on the shoulder of the highway.
Do you remember which way or which direction of traffic on the highway you were? Eastbound or westbound, I guess.
Going eastbound.
Okay. And you said that this individual was on the shoulder. Which shoulder?
The right one, it's like the slow lanes thing.
Okay. What did you do when you saw this individual?
He stopped the ambulance, my partner was driving. I radioed into dispatch to let them know what we had spotted and that we wouldn't be stopping. So that they could send someone else to the call that we were already hitting on. And then. So yeah, I had radioed that, we were stopping. We asked for police to come to our scene. And my partner started to put the emergency lights on. He started to reverse the ambulance to try to get closer to the individual.
You said that you stopped the ambulance. Where did you stop the ambulance?
In the right lane.
In the lane or off the road?
In the lane.
Okay.
It's the lane we were traveling in.
The slow lane,
Yes.
the right lane, okay.
What happened after you started to reverse the vehicle?
He shot the individual. Just started to kind of run towards us. And it looked like he had something in his hand, but neither one of us could see what it was. So we kind of started pulling forward a little bit and we locked the door just in case, because we don't know this person. I radioed to dispatch again that he's charging at us. We would like police to come priority one, which is like sirens, like step it up. Because he could be a danger to himself, to others, we don't know.
At the time that you're seeing this individual, are you looking directly at him?
I was looking in the side mirror, so we have two mirrors basically. It's the larger mirror, and then there's a smaller like toe mirror. I was looking between the small toe mirror, and when my partner said like, "Oh, he's running toward us," I kind of like leaned forward and tried to see him in the larger mirror to see if I could see what he was holding, but I couldn't, and then I just went back to looking in the small mirror.
And you're the passenger, I think, okay.
I don't think I clarified earlier. Do you remember what time specifically you saw this individual?
It's like 2 something.
AM or PM? All right. What happened after you radioed for police assistance?
So we had pulled the vehicle forward a little bit, my partner did. And the individual on the road kind of stopped, like put his shoulders down, turned around and started walking back the way that he had originally been walking.
At that point, do you remember, was this individual on the road or on the shoulder? How far off the road was this individual at that time? What happened after he turned around and started walking away?
I had tried to radio dispatch again to let them know that he was walking towards like a curve in the road, and to let the know so that they don't. I did not get to complete that transmission because it was that.
When you say the individual was hit by a car, do you know what type of car it was?
You can tell that it kind of like continued by my passenger door. I saw the headlights and general.
Can I just stop you there because I'm trying to get it. When you say it continued past your door, that's the vehicle did?
Yes.
Okay, go ahead, Mr. Pickles, sir.
So I saw the headlights, the general outline. I saw that it was a 4-door sedan in darkened color with like not the LED headlights, like the older vinyl headlights. And I saw that it was kind of going sideways, like the headlights were pointing to my door. And it struggled to regain control and then came to a stop ahead of us.
I want to make sure I'm understanding correctly. You said it passed by your door, and you said you're the passenger in this vehicle, correct? When the vehicle passed you, was it on or off the roadway?
It was on the shoulder.
Okay. So it goes past you on the shoulder. Does it go back onto the roadway or does it stay off the road?
It went back onto the roadway as the person was trying to take.
Okay. And while you were testifying, you sort of made a gesture with your hand. it's sort of like fishtailing. Is that what the vehicle was doing?
Yes.
Okay. Were you able to see who was driving that vehicle?
No.
At the time that this happened, were you able to see where on the vehicle, or let me rephrase this question. Were you able to see where the vehicle made contact with this individual?
So when I was looking at the small mirror and I saw the headlights kind of cross the individual turning towards the road, like towards my ambulance. And I saw the silhouette of the individual, and then I heard the of contact. And after we got out of the ambulance to try to look for him, the victim of the driver, there was a specific type of glass that was on the roadway. It doesn't come from a windshield, it only comes from the side windows.
You said that you heard the thud. Did you hear any like tires squealing?
Yes, it did.
How long before or after the impact did you hear that noise?
I only heard the tires screeching right before the thud, and then I didn't hear them screaming.
I believe you said that you left and tried to find the individual that was hit. Did I hear you correctly?
Yes.
Were you able to find that individual?
Yes.
Where did you find that individual?
And started our search where we had last seen him. And kind of scanned the area. We scanned as wide an area as we could, really. Go anywhere. We found him 100, maybe 150 feet up from where we last seen him. There's like a stop wall on the highway. Found him up against the yeah.
Make sure I'm understanding correctly. You said about 100 to 150 feet. Is that off the side of the road or forward, backwards? What direction is that?
So it's forward and maybe 5-ish, 6-ish feet to the right towards the south wall.
And when you say forward, is that the direction of travel the car was going? Okay.
So, okay. And so the individual that struck is now ahead of the ambulance?
I believe he ended up maybe around where the ambulance was.
Gotcha. Okay, so, and excuse me, I'm just trying to get a layout in my head. Where on 94 are you?
So we are eastbound, just west of Robsonville exit.
Just west of Rossendale. Gotcha.
So I wish I had a map to show you.
No, I got it. So you're just west of Rossendale. Okay. And described the individual initially coming toward the ambulance, then going away from the ambulance. How, at the point of impact, how far estimating is he from the ambulance?
I wouldn't be able to give you a good estimate on that.
Okay, that's fine. And but and your ambulance is still in the right-hand lane of I-94.
Yes, we put it in park.
Got it. Okay. Last question I have for you at this point. When you are describing, just so the record's clear, when you're saying on the shoulder, tell me what you mean by shoulder, rather than trying to put words in your mouth. Okay, what you mean.
The solid white line that has.
Got it. So, gotcha. So when you say shoulder, anything which would be to the right of that white line, you're describing as the shoulder. Thank you. Go ahead.
Thank you. What did you do when you found the individual who was struck?
My partner made first contact. Let's read more details on what. But I don't know, it was maybe like this deep, like a foot deep, and it was filled with water. He put a backboard over it, crossed it, got to the victim, and said, "I think I feel the pulse." And so I determined that we needed to get him into the ambulance to do a further assessment on him and perform life-saving measures.
At any time that you're doing this, did any individual from the car that struck this person leave the vehicle and assist?
I could not see or hear any car doors opening or anyone get out of it.
How long did the car remain on scene?
I don't know how long. When we found him and I looked up, the car was gone.
How long did you spend searching for the decedent?
Less than 30 seconds.
So sometime within then, that other car left. After you got this individual back into the ambulance and you were performing life-saving measures, what happened then?
I had radio to get a supervisor. The supervisor showed up and another unit from our same company that happened to be going that direction had also stopped to give us some help. They got in and I was doing chest compressions and the way that our protocols work, if it's what we call a traumatic arrest, so no pulse, no breathing due to a traumatic cause, we have to put them on the cardiac monitor, look at their heart rhythm, and then call a doctor based on that. So that is what we.
Were you able to, or let me phrase the question this way. Was this individual pronounced dead at any point that night?
Yeah.
Do you remember what time that was?
I would have to look at my report.
Were you able to identify who this individual was?
I believe like we didn't. We got his name later from, it was either the coroner or police found out his name. I don't know.
Okay, that's fair. And just to be clear, when this crash occurred, was this in Washtenaw County?
Yes.
Other than yourself and the vehicle that struck the decedent, were there any other cars on the road at this time? Did you observe anything like a deer crossing the street or anything like that? What was the weather like?
Just a regular night.
I may have just one moment here.
And also, I just want to clarify something while you do that. At the time of impact, all of your lights on your ambulance are activated. Okay.
Ask the witness, Your Honor.
Okay. Cross-examination.
So, Ms. Grady, you remember talking to the police on the night that this happened, right? I believe it was Trooper Ryan that interviewed you on the scene, right? Okay, sure. So one of the police officers interviewed you on the scene that night, right? And do you remember telling that officer that you witnessed a small black sedan hit the decedent? I'm sorry, just for the record, we need a yes. Okay. And you gave a lot of information today, details about distances and things you remember. Do you remember if you gave those details to the officer the night that this happened?
I don't believe I gave distance details.
Okay. Do you remember going into specifics about what you saw in terms of the man on the side of the highway the night that this happened?
Because we just saw him.
Do you remember telling the officer specifics about like where you saw him and what he was doing on this evening before the crash? Okay. But you don't remember giving the estimates as to the distance that he was located near the side of the highway, is that right? Okay. And I do want to clarify something as well. You said you located the decedent up against, you said a sound wall. Could you explain what that means?
The wall that's on most highways to prevent highway noises from going to neighborhoods.
Okay. And you remember, you testified on direct that you were looking in the area, you were looking for the decedent, right? Do you remember seeing a variety of debris in that area as well? Do you remember seeing actually parts of cars in that area?
What ended up being a flood flat from a semi that said Volvo on it. It was broken apart. It was in the shoulder.
Okay. And do you remember there was also a back panel of a car from Cadillac? Do you remember that? Okay. Do you remember there being a variety of debris in that area though? There's debris. There's garbage, right? Okay. Do you wear body worn cameras? Okay. And you don't have dash cams on your ambulance, on your vehicle, right? Okay. Do you now? Okay. You also mentioned that there was sort of a ravine that was filled with water. You'd agree with me that that creates some uneven terrain on the shoulder, right? And you testified that your partner actually put I forget what you called it, but some sort of, you said backboard. Okay. And that's so that you could walk over it safely, right? And I want to ask you some more questions about the sort of what the highway, this specific location of the highway. So you testified that there was a curve in the road. You agree that there's, as far as I-94 goes, it's a pretty substantial curve at this location, right? And so you testified that you heard tire screeching before you heard a thud of an impact, right? Did you see the brake lights on the car or do you not remember?
The brake lights weren't facing me until it was in front of the ambulance. So no.
Okay. Could you see tail lights or rear brake lights or not? Okay. How many seconds would you say you observed the individual who was the decedent on the side of the highway before the accident?
Don't know how many seconds. I would say it was easily 2 minutes.
Okay, 2 minutes.
Sometime at least saw him stop, stood, go back and forth, but then it was.
Okay. So you saw him, did your partner stop the vehicle pretty instantly after you saw him?
As safe as possible.
Okay. So you saw him stop the vehicle and then he reversed the vehicle, is that right? And were you observing him in the rear view mirror for that duration of the time? The side mirror. Okay. And you said at one point he was approaching your vehicle, so you locked the doors, right? And I'm sorry, just for the record, is that a yes? Okay. And you actually testified on direct that you thought he was maybe charging it at you, is that right? And you saw something in your hands. Now, would you describe that object as being larger than the side of a kind of standard hand that he was holding? Okay. Could you tell whether it was, what type of object it was?
Not at the time.
Okay.
It looking at what was left in the road in the area was kind of just figured it might be the mud flat, but we don't know for sure.
Okay. But you don't recall seeing many specifics as to the object that he was holding in his hand. Okay. And to be clear, it wasn't really your job to look closely in the scene once you found him. Is that right?
To our best to get as much information that would lead to treating the patient. But not in like the police officer, law enforcement out there.
Okay. Were you aware of any prior calls made regarding that individual before you stopped? Okay. When you talked with, was it you that talked with the dispatch? Okay. Did they mention that they received prior calls about this individual as well?
Found out later that they had, but I don't believe at the time that they did.
Okay. Do you recall how many calls they received about this individual that evening?
I'm not in the dispatch office, I don't know.
Okay. So do you recall how long it took police to arrive on the scene once you made that request?
I wouldn't be able to tell you a specific time, but
Okay.
say anecdotally, it was very quick.
Okay. So you mentioned you had a supervisor come to the scene. Is that standard protocol, or what led to that decision?
Things hitting the door and listening to the ambulance. I thought that something hit our vehicle. It turns out it was just ground and stuff with the shoulder. There wasn't any actual damage.
Okay. At one point, did you think that the vehicle that had hit the decedent also hit your ambulance?
I didn't think that the vehicle itself did. I thought that maybe something had come off the vehicle and hit our ambulance.
Okay. Is it fair to say that in the moment that you were talking to the police the night this happened, there was a lot going on, right? And your primary focus was tending to the patient, right? And you were saying information about what you thought you remembered in that moment while you were tending to the patient, right? So you didn't know if something had hit your vehicle, right?
Once he was pronounced dead, I went and looked at our ambulance to see if there was any damage.
Okay. You testified in direct examination that there weren't any other cars on the road at this time. Wasn't it the case that you radioed for another ambulance to go to the location you were initially headed towards?
That is not our job to do. That's the dispatcher's job.
Okay. Just to be clear, you did see other vehicles driving on I-94 that evening, right? You did see other vehicles driving in that location while you were talking to police, right?
When you're talking to police, they had already shut the highway down.
Okay, so they shut the highway down. Before they shut the highway down, there were other vehicles traveling on I-94, right?
I didn't see my ambulance performing active.
Okay. So before the accident, you had seen other vehicles traveling on I-94 that evening, though, right? During your shift. And that was around 2:30 in the morning, right? Now, I want to talk to you about some more about the investigation in this case. So you talked with the police the night of. Did you ever have any follow-up interviews with any police officers?
Yeah, exactly.
Yes.
So the last court date that we got.
Okay. And then who did you speak with the last court date?
Sorry. Just the prosecutor.
Okay. So did the police officer do a subsequent interview with you at all at the last court date? Okay. So it was just that evening, as far as you can remember, that you gave your statement to police, right? And just to be clear, you couldn't see, it was obviously very dark outside, right? And the vehicle that struck the decedent, you couldn't see inside that vehicle, right? You don't know how many people were inside that vehicle, right? You don't know the race of the person driving, right? You don't know if it was a man or a woman. You have no idea who that was, right? Okay. I have no further questions at this time.
You redirect.
No, Your Honor.
Ma'am, I just want to make sure you're indicating that the point of impact was west of Rossendale Road or west of West? West of Rossendale Road. So the entrance exit to Rossendale, you're on the western side of that. Yes. Okay. Thank you. Anything else based upon the court?
No, Your Honor.
All right. Thank you. You may step down. May I call your next witness?
People call Sergeant Ryan Bowden. I believe he may have just stepped into the restroom.
All right, that's fine.
There it is.
Sir, please come forward and be sworn.
Please right hand. Do you solemnly swear affirm the testimony about to give us the truth, the whole truth, and nothing but the truth, so help you God. I do. State your name and spell your name for person.
Name is Ryan Bowden, RyanBoden.
Certainly.
You may inquire.
Thank you. Good morning, Sergeant. How are you doing?
Morning, sir.
Sir, how are you employed?
Currently as a sergeant.
How long have you worked for Michigan State Police?
10 years.
In what capacity over that 10 years?
Trooper up to September of 2025.
And is that when you got promoted to sergeant?
Yes.
Were you working for Michigan State Police on or about June 6th of 2025?
Yes.
And on that day, were you ever asked to assist with investigations related to a crash that occurred earlier in May of that year?
Yes, I was.
How were you assisting with that investigation?
I was asked to speak to an individual who advised he has information about that incident, and then later on to inspect the vehicle and attempt to interview someone possibly.
At any point on June 6th of 2025, did you have a conversation with an individual by the name of Corey Folk?
Yes.
Do you see that individual in the courtroom today?
Yes.
Can you please point to them and identify them by an article of clothing that they're wearing?
Sitting to my left, wearing a blue suit and a red tie.
The record may reflect the witness has identified the defendant.
Without objection, the record shall so reflect.
Why did you speak with the defendant on that day?
The initial conversation that I had that morning, that person identified Mr.
Objection.
What's your objection?
Well, hearsay and also relevance, we already have
The statement is going to go to his state of mind as to what he did. So it's not hearsay. Objection's overruled. Go ahead, Mr. Cook.
I didn't know what I had as someone who may have been involved. And so I was attempting to interview him as to Cambridge
And when you say attempting to interview him, who is him? Okay. Were you able to interview the defendant? Where did that interview take place?
At the State Police Jackson Post.
At the time you interviewed the defendant, had you taken him into custody?
No.
How did the defendant arrive at the Michigan State Police Post?
Transported him there.
Did he agree to get transported there? At any point, let me rephrase this. Did you advise him whether he was free to leave at any point?
I did.
Was he free to leave at any point?
Yes.
Did the defendant agree to speak with you on that day?
Yes.
I want to sort of go the day before May 25th to May 24th. Did the defendant say when he woke up that morning?
Yes.
When did the defendant say he woke up on the 24th? Over the course of the day of the 24th, where did the defendant say that he was that afternoon?
We say he worked and then attended a Detroit Tigers game.
When the defendant was at the Detroit Tigers game, did he say whether or not he had anything to drink? What did he say? What did the defendant say he drank?
Initially advised he had a couple of beers, and that can be later clarified.
At the time of that,
Sorry, what was that last word?
Three.
okay.
Yes.
At the time of the Tigers game, do you know how old the defendant was?
Under 21, but I do not know exactly.
Did he say if he was with anyone else that afternoon?
Yes, he did.
Who was he with?
A friend of his named Adrian Putnam.
Defendant says he's at a Detroit Tigers game. How long did he say he was at that Tigers game?
He stated he arrived to the Detroit area 6:30 and stayed until approximately 11.
Where did the defendant say that he went after the Tigers game?
Ann Arbor.
Did he say what he was doing in Ann Arbor?
Is that pinball piece?
How long was the defendant in the Ann Arbor area?
He stayed until approximately 2 to 2:15 a.m. the fall.
Of the 25th? All right. Where did the defendant go after, or where did the defendant say he went after he left Pinball Pete's?
He said he went to take towards Allen Park to take his friend home.
Did he say what route he was taking to get there?
He did not know the exact roadways, but he stated it was the freeway and he was traveling towards Allen Park, so east.
While the defendant was driving towards Allen Park, did he say how fast he was going on the freeway?
He approximated his speed around 90 miles an hour.
While on the freeway, did he say whether or not he was distracted by anything?
Yes, some flashing lights.
What about the flashing lights, or what statement did the defendant make regarding these flashing lights?
He advised he saw some flashing lights as he was on the freeway, and he believed that they were on the other side of the freeway, so the westbound side, and that's when he saw that.
Did the defendant say how hard he hit his brakes? Did the defendant say whether or not he was able to maintain control of his vehicle?
He's not able to maintain control of his vehicle.
Did the defendant say whether he was involved in a crash at that time?
Yes, he stated he collided with something.
What did the defendant say he did after he collided with something?
Looked around, asked his friend, he was okay. Sat there for 2 or 3 minutes and then left.
Did he ever tell you that he got out of the car and rendered aid or assistance to anyone?
He said he did not get out of the car.
Did he ever say if he reported this crash to police?
Said he did not report.
Did he give a reason why he didn't report this to police?
He was afraid of the show.
Did he say where he worked? I'm sorry.
Yes, it was in Jackson. I can't recall the name of the company, but he was afraid a driving charge would cause him to lose that job.
A drunk driving charge. Thank you. Go ahead.
Other than drinking, did the defendant say he used any other sort of intoxicating substance?
I asked him and he stated.
Okay. And did the defendant say what vehicle he was driving?
His vehicle is Chevy Malibu.
What sort of vehicle is it? An SUV, a truck, a sedan?
Mhm.
Did the defendant say whether he was using his phone at the time of the crash?
He said he may have done.
Did you ever personally see the defendant's vehicle?
Yes.
When you observed the vehicle, was there any damage on it?
Yes.
What sort of damage was on the vehicle?
Dent, I guess that's described as a dent on the rear quarter panel,
Which side?
right side.
So passenger side? Okay. What about the windows? Were the windows damaged in any way?
There was a,
Which window was broken?
I do not recall.
If I can have just one moment, please, Your Honor.
Yes, ma'am.
Ask the witness.
Cross-examination.
So Sergeant, you testified on direct that he said he did not report this to police. You actually got his name from Trooper Davis, isn't that right?
Mr. Davis is not a trooper.
Mr. Davis is employed at the police, isn't he?
I believe he may be your corrections.
Brief moment, Your Honor.
Yes.
So you're aware that Mr. Davis is employed in some capacity with police? Or you don't know?
Like I said, I believe these corrections, which
Okay.
entity that belongs.
You say you believe. Do you remember or do you not remember how he's employed?
I believe he's a corrections officer.
Okay. So do you recall, was it you who followed up on the conversation with Mr. Davis or was it not you?
Yes, I did follow up.
Do you recall referring to him as Officer Davis?
I may have.
Okay. And do you recall which agency you called to follow up on this information?
No.
Okay. But, okay. So do you recall that you actually called a police agency regarding a call that Mr. Folk made about this?
It was his supervisor.
Okay.
So
Is
Mr. Davis
the supervisor?
is the one who contacted our post regarding this entire instance.
Got it.
Okay. And was it a part of your responsibility to investigate anything that Mr. Folk told you?
I was assisting at that time. I was not the officer in charge of the investigation. So I was merely asked to interview Mr. Folk and check on the vehicle.
Okay. So did you ever go view the surveillance cameras at Pinball Pete's to verify what time he may have left or what time he was there?
No, I didn't.
Okay. Did you ever ask any of the other officers to do that?
No.
Okay. That wasn't your part of your responsibility in the investigation? Okay. Did you ever view or request to view any surveillance from Detroit, from the Tigers game regarding, okay. You're aware that you had information that the damage to Mr. Folk's car was actually caused in Detroit at the Tigers game, right?
That's what he initially told me, and then he changed that statement later on.
He told you his rear window damage was from a break-in in Detroit, right?
That's correct.
You're saying that that part of the story, that the window damage, specifically the back panel, I'm not talking about the siding of the car, but the back window, you're saying he changed his story about that damage?
Changed his damage to the
He told you that he had a witness who would verify that his car was actually broken into in Detroit, right?
Yeah, I was part of this interesting.
Your Honor, permission, well, brief moment, Your Honor. Sergeant Ryan, you would, or Sergeant Bowden, excuse me, you would recognize a copy of the written report you made about this, right? Permission to approach the witness?
Okay.
May I approach physically?
Okay.
Okay. Can you point out where in the written summary of your interview with Mr. Folk, you indicated that he changed his story about specifically the back window?
To object to the development.
Well,
I'm also hearsay.
yes, but note those, but I'm trying to figure out where, when you say back window panel, what are you referring to in your question?
So the rear, basically the window, the rear window of the vehicle.
Well, I don't know what you mean by rear window. Are you talking a side window to the rear, or are you talking the rear window?
I was referring to the rear window.
All right, go ahead. As to your objection, G, well, the first one is to relevance. Maybe I'll overrule that objection. As to hearsay regarding the defendant's statement, isn't it hearsay?
Your Honor, I'm asking this officer to point out where in his written statement summarizing, he indicates that Mr. Folk changed his story about this back window panel.
All right, I'll allow it. Go ahead.
Sure. This portion here, if I may read it to you. I advised Folk his statement did not align with some information he had about his vehicle. It offered him the opportunity to clarify, which he replied, I couldn't tell you. I again offered Folk a chance to start over, as I did not feel his initial statement was entirely accurate. At that point, Folk stated he was taking his friend home after the Tigers game, spending time in Ann Arbor. After that point, he describes the damage as occurring as part of this collision that occurred after the Super Bowl.
Okay, so to be clear, did he ever tell you that his car wasn't broken into in Detroit? Did he ever say, actually, that was a lie?
Did he verbatim state that to me?
Did he?
No, he did not verbatim state, but this is the point in the interview, which he then clarified his initial statements and said that the damage actually occurred during this collision on the freeway.
Okay, but just to be clear, you never investigated. Actually, you did ask him where he parked at the game, right?
I did.
And you were trying to get some of that information, right? May I retrieve the police report? Thank you. You did think that was relevant to your investigation, right? When you were asking questions about where he parked at the game, you actually thought that was relevant to your investigation, right?
Part of the way we interview people is to obtain their full statement initially, and then point out any discrepancies that may be there in obtaining the truth later.
Okay. You started the interview by saying he wasn't in custody. Is that right?
Told him he was free to leave at any time.
Okay. You did not read him his Miranda rights, correct? You did not have him sign a waiver of his rights, right? You did not tell him he had the right to an attorney. And you physically drove him to the police station, correct? And he told you he thought he had to go with you, right?
Yeah, we had a conversation.
Okay. And there was you, and then there was another police officer who was in the interview room with Mr. Polk. Is that right? And both of you were wearing your uniforms, right? And you had your weapons on you, right? And you were sitting on either side of him, right?
Yes.
And he was not sitting immediately. He was sort of sitting in the corner of the room, right?
Yes.
He was not sitting right next to a door, right? And you told him that you've been doing this a while and you felt like he had a moral compass, right?
Yes.
And in fact, told him that it didn't seem like he should go to jail, right?
I don't know that I see that.
You told him he didn't seem like a bad guy, right?
Yes.
And you don't remember saying doesn't seem like he'll go to jail? No. Okay. Okay. And he asked you if he needed a lawyer. You remember that? Sure.
I believe we were talking about going to jail that day after the interview.
I see. Okay. And in fact, you promised him that you wouldn't seek charges if he had hit an inanimate object. Isn't that right?
I believe I told him that I was not worried about leaving the scene of a property damage.
Okay. You promised him you wouldn't charge him with that, right?
Well, I'm good. What relevance would it have? The officer doesn't charge.
That's correct. But if the people are intending to use my client's statements as substantive evidence against him, his confession, which I believe they are, as that was the entire direct examination, then anything that has a bearing as to the credibility of his statements, including any promises that were made or implied by this officer in order to obtain those statements,
Would do what?
could impact the credibility of those statements and therefore the evidence.
It's sustained. Yeah, that doesn't make any sense.
Did you ever follow up with the witness he told you would verify what he was saying, Adrian Putnam?
No, I did not.
Okay. Do you know whose responsibility that would be, which officer?
Normally it would be the officer in charge of the investigation. In this case, one of our detectives was assisting, so maybe him as well.
Okay. And do you recall discussing a pizza place or a pizza restaurant in Ann Arbor?
Yes.
Do you recall the name of which pizza restaurant he was allegedly at? No. Okay. So you didn't follow up on that aspect of the investigation. Is that right?
After the interview, correct.
And you were taking some notes on a notepad during this investigation, right? Did you save those notes?
If it's in my current notebook, it's in my back pocket. It's possible. If it's an old one, I shouldn't.
Okay. Is that a part of policy?
As to relevance again.
I'll overrule it. I'll allow a little leeway. Go ahead.
Is that a part of policy?
I don't know if our policy states or addresses that one way or the other.
You're a sergeant, aren't you? And you were promoted just a couple months after this, right? Did you ever listen to any of the 911 calls on this evening?
No.
Did you ever obtain any police reports relating to this investigation? Were you aware of how many accidents there were on I-94 on this evening?
No.
Okay. Were you aware that there was another accident around the same time frame in that area on this night?
Again, no.
Okay, so you didn't hear those 911 calls?
No, I was not working.
Okay. And you never investigated the scene of this accident, right? You don't have any corroboration about what damage caused Mr. Folks was caused to his vehicle, right?
None other than his statement.
Okay. I have no further questions, Your Honor.
For point of clarification, the record is clear. There was an initial statement regarding damage to the vehicle that the defendant gave that it occurred in Detroit.
That's correct, Your Honor.
Subsequent to that, after additional questioning, he changed that to the damage having occurred on I-94.
That's correct.
Yes. Okay, thank you. You may read your right.
Thank you. Mr.
Yes. Okay.
When you interviewed the defendant, I believe you testified on cross-examination that at some point you made a statement that he thought he had to go with you. Do you remember that testimony? After the defendant made that statement, excuse me, what did you tell the defendant as it related to his requirement to being at the station?
I clarified that he was free to leave, that he was not in custody or under arrest. I don't know. That he was free to leave at any time, and he could end the conversation, the interview, and
Did you ever handcuff the defendant? You were also asked whether you had any sort of corroborating evidence that goes to the damage on defendant's vehicle. Do you remember that questioning? Showing defense counsel's remarks, people's proposed exhibit number 2. I apologize, I'm going a little bit out of order here. May I approach the witness?
Wait. Said exhibit 2.
Have you recognized this document?
yes, let's take the laboratory report.
Can you take a look at that document for me, please?
Sure.
And specifically, what is that a lab report of?
Appears to be from this case, and it is testing some swabs that were taken from the vehicle. And as well as
in your review of that report, is that report a fair and accurate representation of a report or the report that was received on this case?
yes.
And people moved to admit was marked people's proposed exhibit number 2 into evidence.
Any objection or voir dire?
Yes, Your Honor, permission of voir dire.
Go ahead.
So, Sergeant, you have no certification in forensic science, right?
It's broad.
Elaborate between us.
Do you have any certification in forensic science?
Well, that's broad. So you're gonna, yes, it is. So you're gonna have to restructure that question because that is so wide open.
Okay, I was just
Direct question.
sure. Sergeant, you are not a forensic scientist, is that right? And you are not specifically trained in analyzing DNA, right?
In my roles for this department.
Okay. And you cannot testify to specifically what these results in this document means, right? Based on scientific knowledge, training.
I can't testify to the testing procedures.
Okay, to be clear, your name is not on this report, right? The person, forensic scientist, is Abby Newman, right?
Correct.
And in fact, this report was issued at the end of March, right? Of this year, March 2026.
The reports of February 11th, 2026.
Oh, do we have a different report? Your Honor, may I approach the witness to see? Okay.
Can you look to the bottom of that page you're looking at? It says report issued March 26, 2026. Isn't that right? And I can point if that's easier.
Oh, I see.
Right. You see where I'm looking?
Yes, that's right.
Okay. And so your role in the investigation had actually concluded by March 26, 2026. Isn't that right?
My role in the investigation was inspection of the vehicle and interview of Mr. Moore.
Okay. And in fact, I don't know if you know the answer to this, but that was after the initial probable cause conferences in this case. Is that right? Okay. You don't know when the court dates were in this case because it's not your case, right? Okay. I have no further questions at this time, Your Honor. I would object as to, on a number of bases. First of all, I don't think this is the appropriate witness from which to seek to admit this report. His role in the investigation had concluded by then. His name is nowhere in here. He didn't testify as to any specific knowledge or experience or involved in this. So I would object on that basis. We didn't receive a specific notice that this would, be sought to use at exam. This is a situation where it was after the initial probable cause conference.
What is the requirement of the notice that it's going to be used? It was supplied to you.
It was supplied to us, Your Honor.
So what requires the prosecutor to give you notice that it may be used when it's supplied to you?
Well, Your Honor, I would argue, given the
is there a specific statutory or court rule requirement that there would have to be the notice?
Not that I'm aware of, Your Honor.
All right, go ahead.
The people did provide a witness list for the examination today. This is obviously a very, very complicated case and a very specific type of knowledge in order to make the conclusions that are made in this report about DNA analysis. It is possible that we would have sought to have the expert analyze this. However,
there has been a PCC in this case. This case has traveled through. This case was set for exam previously. It was adjourned at your request to today's date. And now you're telling me that you haven't done something and may not be ready. Is that what I'm hearing?
well, Your Honor, I would stand by my objection, Your Honor.
I'm not going to answer my question.
Sure. So a couple weeks is not enough time to obtain an expert. It's not even enough time to, and so a couple weeks would not have been enough. This
didn't just have it for 2 weeks though.
So this report was made March 26, 2026. My notes indicate the probable cause conference in this.
Are you asking them to bring in the author of the report?
Yes.
On what grounds?
To cross-examination in order to ask specifics as to how this was conducted, the testing procedures, the results in terms of 560 septillion times, 8.1 sextillion times, the differences between those two numbers. That would be.
Defense sought to obtain that test or that information from the author of the report.
Sorry, you mean, have I called?
You tried to get to the person that authored the report.
I have not called the author of the report, no.
Mr. Cook.
I don't know if the court needs a response, but I would say I believe this is admissible pursuant to MCL 766.11b, specifically section 1D, that allows at the preliminary examination documents such as laboratory reports to be admitted without the author being needed for preliminary examination.
Response.
Your Honor, I would stand by my objection. I don't think there's been foundation for that.
Objections overruled. Exhibit is admitted.
Thank you.
Any other additional questions of the sergeant?
I would just move to publish that exhibit to the court.
So. Either way, you just try to save steps. You need them. So, okay. Go ahead. Any other additional questions? Any additional questions from the defense?
No, Your Honor.
Okay, thank you very much. You may step down. The court is going to take a brief recess. What I'm going to suggest to counsel, my staff will be able to send you a copy if it went through. If the parties can stipulate on a map as to the exact location of the accident, would be appreciated by the court. If you can't reach a stipulation, then we'll get somebody in there to testify about it. But I'm gonna need a map.
Understood.
All right. Court stands in recess.
All rise. Equals exhibit 3.
All right. Is that correct?
Yes, Your Honor.
All right.
May I approach?
Yes. Thank you.
And for the record, there's an X that is marked in blue ink on that email. That X was made with the troopers. The trooper marked that as where he responded and where he observed the decedent when he arrived on scene.
Got it. So. Okay. So I'm after the, I just want to make sure I'm heading east is to my right.
Correct.
West coming off of that curve. Okay. And so it's in that, it's actually in the stretch between the two curves to whatever extent, but by US 12. Understood. All right. Thank you. All right. Call your next witness.
People would call Trooper Douglas Ryan.
All right. Exhibit 3, if I didn't say so, is admitted.
Douglas Ryan, EOULASRYAN.
All right, thank you. You may be seated. And you may inquire.
Thank you. Good morning, Trooper. How are you doing? Doing well, thank you for asking. Trooper, how are you employed?
State Sheriff, Michigan State Police.
How long have you worked for Michigan State Police?
6.5 years.
And has your duties been consistent over that 6.5 years?
Yes, I have.
Were you working on or about the early hours of May 25th of 2025? At any point, did you go to eastbound I-94 reference a motor vehicle crash?
Yes, I did.
What time about was that?
About 2:28 morning.
When you arrived on the scene, Who all was there?
When I arrived on scene, there was a Huron Valley ambulance rig and 2 EMTs, as well as a Washington County Sheriff's patrol car with 2 deputies.
What did you do when you arrived on scene?
When I arrived on scene, I parked my patrol car on the right shoulder behind the where the sheriff's patrol car and the ambulance were parked. And I got out of my car and saw a man that was lying in the foliage on the right side of the freeway. There were 2 EMTs who were walking up to that man. So I walked up to assist as well.
How far, you said in the foliage, how far from the road was this man?
He was about 10 yards laterally off right side of the freeway. So nearest paved part of the freeway is about 10 yards away from him.
Do you know how far it is from the last paved part of the freeway to the white fog line?
It's about 10 feet or so, almost the shoulder.
Okay. Was this man wearing anything when you found him? What did you do when you arrived with the 2 HVA individuals?
So I saw that the man was limp. He had no front teeth. He had a gash on his forehead. He did not appear to be breathing or moving. So at that point, we decided that we had to administer first aid. So the paramedics or the EMTs brought a stretcher to the man, and I assisted in loading the man onto the stretcher so we could transport him to the ambulance on foot and then put him back to the ambulance.
Were you able to identify who this individual was?
Yes.
Who was it? And when I say this individual, I mean the man that you were transporting.
It was Sean Muller.
How were you able to identify him?
His Secretary of State photo.
Do you know if an autopsy was ever done for Mr. Mullen?
Yes, there was.
Did you receive a report as to the findings of that autopsy?
I did.
Showing defense counsel to Mark Steeple's proposed exhibit 1. May I approach the witness?
You may.
Sir, I'm handing you a document that's Mark Steeple's proposed exhibit 1. Do you recognize that document?
I do.
What is it?
It's the Michigan Medicine autopsy report for Mr. Mullen.
And prior to today, had you seen this report? Is this a fair and accurate copy of the report that you received as it relates to the autopsy performed in this case?
Yes, it is.
Your Honor, people move to admit with Mark Steeple's proposed exhibit 1 into evidence.
No objection.
Action or voir dire.
No, you're.
Exhibit 1 is admitted.
Permission to publish to the court?
Yes. And it up to me. Thank you. Go ahead.
And sir, I realize I just took that document away from you. That document indicate the cause and manner of death.
Yes, sir. It did.
What was the cause and manner?
The cause of death was blunt force injuries, and the manner of death was accident.
One moment, please, Your Honor.
Yes.
And I don't need you to testify anymore to that. So if the court wants to take the document back, I apologize.
It's making us work. Thank you, sir.
That's the witness.
Cross-examination.
Yes, Your Honor.
So I want to start at the beginning. Oh, here's this. I want to start at the beginning of this evening. You were initially dispatched to this location due to the report of a naked pedestrian on the freeway, right? Incorrect. Okay. Why were you initially dispatched to this location?
I was not initially dispatched. There were other troopers who were going to dispatch this off to assist.
Okay. What was the reason they were initially dispatched?
Was a naked man on the freeway who was holding ground.
Okay. Sorry. So you said no to my question because you were not initially dispatched due to the report of a naked pedestrian. You were dispatched because there was an individual with an object in his hand. Is that right?
Okay. So there was another trooper.
Okay.
Troopers were in patrol car.
Okay.
They once a dispatch sent to the call. myself and Trooper Headley, and we offer to assist them in looking for this man. So we dispatch not send us to this call. We offer to volunteer to assist with the call.
Okay, Your Honor, permission to approach the trooper with his report?
Yes.
Trooper, I want you to look at the very first sentence of the report you wrote in this case. It actually says on the below listed date and time, Trooper Heatherly and I were dispatched to the below listed venue for a naked pedestrian on freeway. I read that correctly, didn't I?
Yes, ma'am.
Okay, thank you. And you actually received multiple 911 calls about this pedestrian, isn't that right? And it was while you were en route to that location that you received an update that the pedestrian of interest was struck by a car, right? You did not. So at what point did you receive that update?
City. On the paramedics.
Okay, so just to be clear, it's your testimony today that you did not receive that update while you were en route.
Correct.
Okay, may I approach, Your Honor?
What's the relevance of this?
Your Honor, this is the credibility. He's the officer in charge of this investigation.
And so let's assume for the sake of argument that he received that information in route. Why is that relevant?
Your Honor, his answers to my question as to whether they...
Why is it relevant to me?
Your Honor, the defense in this case and my argument as to bind over is going to be proximate cause. So it matters very much the timing of when the pedestrian was struck as well as what was going on before the accident.
But what, in answer to your question, what relevance is it going to be for me, even as to that issue?
So it makes a difference whether he was there when the accident happened or whether he...
Not claiming to be there at the time the accident happened.
So he's the officer who's in charge of this investigation, and he testified just now that he was not en route when he received any update. So I'm trying to figure out, again, just the timing of the series of events, what updates he received, what his investigation consisted of.
In what way does that relate to proximate cause?
First,
where this trooper may have been. How does that, help me to understand how you even get there.
Okay, so first of all, it is foundational, right? His investigation, I would argue, is very important to this case. So I'm asking details about the information he had at the time and also the information he has now. His testimony.
So how does it relate to proximate cause?
It is foundational to the investigation.
Any response on it? Go ahead, but make it quick, because this is illogical to me.
So, Trooper, if you can read the second sentence of your report silently as I read aloud, it says, while we were en route, HPA advised that the pedestrian had been struck by a vehicle. I read that correctly, didn't I?
Yes, ma'am, it's correct.
Do you remember how many 911 calls there were about that pedestrian? Okay. Did you listen to all of them? Okay. Did you ever obtain any of them?
No.
Did you listen to any of them? No. Okay. As the officer in charge of this investigation, would that be a part of your responsibility or someone else's?
So,
okay. And you didn't provide those to the prosecutor, right?
correct.
Okay. So you don't know what time the first 911 call came about this pedestrian, right?
It's a
Would it refresh your memory to review a copy of your report?
yes.
Okay. May I approach, Your Honor?
So you can take a minute and look at your report. And
So the first call that was received at 1:03 a.m. by Van Buren Township PD.
Okay. 1:30 a.m. You said, I'm sorry, you said 1:03?
1:03 a.m.
Okay. Do you know what time the last call, 911 call, was received?
2:28 p.m.
Okay. All right. And once you began investigating, oh, may I approach to retrieve the police report?
Right.
Thank you. Once you began investigating, you realized that there were numerous police reports relating to the erratic behavior of the decedent immediately before the accident, right?
Police reports.
So you learned there was a police report from just hours before from Westland regarding suspicious circumstance of the decedent, right?
Later.
Okay. So later in your investigation, that's something you learned? Okay. Did you ever get a copy of that report? Okay. And so you never gave a copy to the prosecutor, right?
That's correct.
But you did talk to Sergeant Larson about this, right?
Yes.
And you learned again of the erratic behavior of the decedent from May 24, 2025, right?
Check.
20 years.
This is foundational to his investigation.
No, it's not. It's still hearsay.
I'm asking him about.
Objection is sustained.
So did you ever in your investigation come to learn of any details within the police reports concerning the decedent the day he passed? Okay, so you did learn of those details during your investigation, but that was not by reading the police reports. Is that right?
That is correct.
Okay, that was just by having a conversation with a couple other officers?
Yes.
Okay. And about a month before this incident, there were other police reports concerning mental health issues, right?
Objection.
Relevant.
Relevance as to, again, proximate cause, his behavior and his actions leading up to his death severs the criminal liability in this charge.
You got case law on that?
I do. It is, well, the jury instruction references the intervening superseding cause. People v. Schaefer.
Where would the intervening superseding cause be? I'm aware of that, but where would it be under these circumstances?
So and I'm happy to continue.
Answer my question.
Sure. So if there's an individual who was high on cocaine as well as other controlled substances, had mental health issues, running around the freeway at 3 a.m. naked, that would constitute an intervening superseding cause that severs the proximate cause, that severs the criminal liability. And again, that's People v. Schaefer, 473 Mich. 418, 2005.
So I'm going to let you go. That's not what that means, but go ahead.
Okay. So, Trooper, about a month before this happened, there was contact with the Warren Police Department regarding mental health issues.
What is the relevance of something a month before? How does that become a superseding or intervening cause?
Well, I have two.
Just proffer it to me.
Okay. The first is it relates to his lack of investigation. And the second is
whose lack of investigation?
The police. If they're aware of potential police reports regarding an individual involved in a case from a month prior and they don't get those reports, that goes to the credibility of their investigation.
No, it doesn't.
Okay.
What's the other theory?
So the other theory would be if there was mental health, erratic behavior of someone who's naked on the highway at 3 a.m, that could explain why potentially they would be running around a highway naked at 3 a.m. And it that I would argue would constitute a legal division of criminal liability in this case, criminal responsibility.
I think your legal analysis is absolutely wrong in regard to superseding or intervening cause. I'm going to sustain the objection. I'm not going to allow testimony.
Okay. So I'm not sure whether I can ask the next question, but I'll ask it and wait for the court's ruling. Did you learn of whether the decedent had any ongoing legal issues relating to his mental health?
Won't object as to relevance again.
Same.
Okay. So to be clear, this is not a case where it was a head-on collision. Is that right?
Correct.
This was an allegation that the rear of the vehicle came into contact with something, right?
Not the rear of the vehicle. Okay.
Okay, which part of the vehicle do you allege came into contact with the decedent?
The right side or
Right. Okay, so just to be clear, you're saying it was not the back of the car, it was the right side of the car. Okay. But again, that's not the front, right? There was no evidence whatsoever in your investigation revealing the front of this car came into contact with anything, right? You were in charge of investigating the area the decedent was located in, right?
yes.
And you found a variety of auto parts, car parts in the foliage where he was located, right?
Yes.
And in fact, one part had a VIN number stamped onto it, right? Okay. You don't remember if any of the vehicle parts found near the decedent had any VIN numbers on them? Okay. May I approach the witness, Your Honor? Okay.
You can take a minute. Would it refresh your memory to take a look at your police report?
It would.
Okay. Take a look at the police report.
And did that refresh your memory? So you did find a car part that had a VIN number stamped onto it, right? It's your testimony, you did not. May I approach the witness, Your Honor?
Did your partner find a car part that had a VIN number stamped onto it in the area?
No.
Okay, so just to be clear, that if I was to say a black auto part was found with the VIN number stamped onto it, you're saying that's not correct?
Yes.
Okay.
May I approach the witness again?
Right.
Officer, what did you mean when you wrote this then?
By the way, he's a trooper, not necessarily an officer, so you'll address him correctly.
Okay.
Go ahead.
Just for clarification, so I can follow along, what page of the report are we on right now?
Oh, sure. It's page 2, the first paragraph, towards the end.
Yes.
Well, can I just ask what part of your investigation was the basis of this section of your report?
So the number I believe you're referencing is not a thing.
What number is it?
The number right there.
Yes.
Someone got my number. Give you characters.
Do you know what number that is?
No.
Okay. Did you ever ask anybody?
Not good research. The internet.
Do you remember what your research showed?
That it belonged to a specific make and model of car.
Okay, and you found that it belonged to a specific Cadillac, right? From 2006 to 2009, right?
Yes.
To your knowledge, Mr. Folk has never driven a Cadillac, right?
Objection, speculation.
Sustained.
Okay. Was there ever any part of your investigation that connected Mr. Folk to a Cadillac? Okay. You also found other debris in the area, is that right?
Yes.
And in
We
fact,
go through every piece of debris that may be found on I-94.
no, Your Honor, I'll move on.
Thank you.
You also found that there was a ravine located near the decedent, is that right?
Yes.
Okay. And you'd agree that that created some uneven terrain, right?
Yes.
And just a couple more questions about this issue. You didn't photograph all of the debris that you found on scene, right? And you didn't log them into evidence, right? Do you recall getting any calls about other accidents during the same time frame? Okay. In fact, there were a couple other accidents involving injuries, right? Okay, but you recall getting calls generally? And when you were driving on I-94, you saw there were other vehicles driving there as well, right?
Yes.
Was it your responsibility to search the car associated with the decedent?
No.
Okay. Did any police officer ever search that car for evidence? Okay. Which officer do you think would, or is there any police officer that would know whether the decedent's car was ever investigated? You attempted to locate cameras that might have captured evidence regarding this incident, right?
Yes.
You were not able to find any license plate readers in Washtenaw County, is that right? And you didn't find any flock cameras in Washtenaw County, right? Did you seek to view any surveillance videos from any of the businesses nearby? Okay. You did review the defendant's statements made to law enforcement, right?
Yes.
You were aware that he indicated he was at certain businesses around the county, is that right?
Yes.
Did you ever ask to view their surveillance videos? You are aware that many private businesses in Washtenaw County have surveillance cameras, right?
Yes.
So I want to ask about the crash reconstruction investigation. You did have a crash reconstruction expert analyze this case, is that right?
Yes.
And you're aware, probably you were aware that the Bosch crash data was obtained, is that right?
Yes.
And you reviewed their investigation, right? And they did ACM imaging, right? Okay. You're aware that no speed determination was able to be made, is that right?
I know.
Okay, you don't remember if there was any determination that was able to be made as to the speed of the vehicle? Okay. And I know that people admitted a map of the incident of the accident, but your investigation, the crash reconstruction expert indicated that there's no way to determine exactly where the decedent was struck. Is that right?
Sustained.
And just to be clear, do you remember the name of the crash reconstructionist? Okay, what was their name?
Yeah.
Okay. And did you oversee his investigation? Okay. Who did, if anybody? Okay. Would you say it's common in vehicular homicides to have no black box data indicating speed whatsoever?
I would say she's on top of the
How many vehicular homicides have you been the officer in charge on?
2.
Was this the first? Okay. Did you review the black box data in the prior one? So did you actually review the black box data for this case?
Yes.
Okay. Were you able to make any sort of, did you learn anything from that?
I don't recall.
Okay. And I know you were here in the courtroom when Sergeant Bowden was testifying about his interview with Mr. Folk. Were you the officer, or I'm sorry, the trooper that requested he interview him?
No.
Okay. To your knowledge, Mr. Folk.
To my dad's back to the area. I had already called Talbot House about the services that they provide. I had just completed Talbot House last year, a good few months, like 6 to 9 months of being there, and I completed, and I called them to try and go back to see what services that they could provide for me.
Your Honor, I was not aware of Talbot House. Treatment did not inform me of any of that.
Treatment also knew that I was going to try and continue mental health services via telehealth with them until I got into Talbot House.
Who is Jason Starr?
My boyfriend.
Is he on supervision right now?
No, sir. He's never been in trouble.
So you're saying that you never indicated to Officer Rose that you were not willing to participate in treatment or supervision?
No, sir. Treatment that I was at was also trying to get me to do via telehealth with my probation officer. It was not something that me and probation had discussed at all. It was something that treatment wanted to do to make it easier on them. So I told treatment, I wanted to continue treatment with them, that we had talked about a place called First Step. It's First Steps. It's a mother's program here in Cincinnati, because I do have 2 children that I lost custody of when they were newborns. So there's still so much that I need to experience and learn that I never got to. So I wanted to continue in a mother's program. And there was talk of that. I had took it upon myself to call Talbot House myself. There's mental health that also knew that she had told me to tell the clinical director that I wanted to continue mental health services with her via telehealth because I could continue to do that and still utilize their services as long as I was still seeing my providers.
Okay. Miss Oliver, I'm going to have you reassessed. Would you get a new assessment on her, please?
Yes, Your Honor.
I'll have you reassessed and determine what level of treatment. At this point in time, I'm gonna just set this out about a week. Let's get this sorted out. So I'm gonna hold you in the county jail for now. I'm gonna reset this for 1 week. Did you have something else you wanted to say?
No, sir.
Okay. And then we'll get a better idea of what the plan is, okay? All right, that's all. Let's see. Good morning. These are case numbers 23CR40537, 23CR40919, the state of Ohio versus Rebecca Mullins. Ms. Mullins is before the court on an ILC and final probation violation hearings. Mr. Madden, does your client wish to have a hearing?
No, Your Honor.
Ms. Mullins, you understand you're entitled to have a hearing?
Yes, sir.
Yes? I need you to answer out loud for me.
Yes, Honor, I understand.
All right. You wish to waive that hearing and admit to the violations?
Yes.
All right. Where are we at, Mr. Madden?
Well, Your Honor, I met with Rebecca on Saturday, and she expressed to me that she would like to avail herself of an inpatient intensive treatment program. I don't want to give up on her yet. I think it's time to send her to prison. I told her, if you graciously agree to this, and this is it, if she doesn't get through it, when she fails in some way, she is going to prison. I know she wants a chance, Your Honor. Her mom and son are in court today. If that doesn't keep her on the straight and narrow, I don't know it will. Have a 12-year-old boy like that. And so that's what she'd like.
Officer Ruff, is a CBCF your recommendation?
Yes, Your Honor.
All right. At this point in time, Ms. Mullins, despite this violation, the court will, if she's going to do that, then I'll continue ILC at this point in time on the felony. You ordered to successfully complete a community-based correctional facility with any recommended aftercare. When you completed that program, you'll be on electronically monitored house arrest for a period of 90 days. All right, we'll give it a shot. So you'll get that referral out right away?
Yes, Your Honor.
Okay, all right, thank you.
Continuously asked if it was him who did this, right?
I don't know.
Okay. Did you review his statements as a part of your investigation? Okay, but you don't remember whether that was a question he asked? Brief indulgence, Your Honor.
Yes.
So the people's admitted this exhibit in their questioning of you. And you're aware that the autopsy revealed multiple controlled substances within the blood of the decedent. Is that right?
Yes.
You're aware that active cocaine was found in his system, right?
Yes.
And you're aware that the benzoylecgonine, which is the metabolites, 3,600 milligrams or nanograms per milliliter were found as well.
Yes.
As well as another controlled substance, ecgonine methyl ester. Is that right?
Yes.
You have no external evidence about exactly what the decedent was doing in the moments leading up to the car accident, right?
Other than the statements of the witnesses, no.
Your Honor, I have no other questions at this time.
Any redirect?
No, Your Honor.
All right. Agree, Mr. Tepe.
Your Honor, people have no further witnesses and will rest at this time.
Any witnesses for the defense?
No, Your Honor. Defense rests.
Your Honor, people have moved for bind over on the information specifically on counsel 1 and 2. Briefly, I think count 2 is going to be the less contested matter. I think certainly by probable cause standard, people have shown the defendant was involved in a crash on I-94, that he failed to stop and render any assistance or to report that crash to law enforcement, and that he knew or should have known he was involved in a crash, and that crash resulted in the death of Mr. Mullen. I know defense has said that they think this is a proximate cause issue, specifically as it relates, I believe, to count 1. I think count 1 is actually more of a mens rea issue as it goes to the degree of defendant's driving, whether it was reckless or careless. But I think there's 4 key factors that make this reckless and not simply careless. And those key factors are the defendant's admission to consuming alcohol, the defendant's admission as to the speed he was going, the amount of time it had been since the defendant last slept, and the possibility that the defendant was on his phone. As it relates to alcohol, the court heard testimony that the defendant admitted having consumed alcohol earlier in that day. I believe he said a few, and then it was clarified to be 3 beers at a Tigers game. Certainly 3 beers is something that someone could handle with the defendant. I would again note is under the age of 21 and should not have been consuming any alcohol that day. As it relates to the defendant's speed, his testimony was that he was going 90 miles an hour. That's, as the court knows, well above the posted speed limit on the highway, about 20 miles per hour over. The ambulance, the HVA witness was able to hear screeching of the tires as the defendant tried to brake, but then apparently swerved off the lane of travel over the shoulder and onto the passenger side of the HVA vehicle, which was itself parked in the right-hand lane. So he went off the road as he swung out and lost control of his vehicle and hit the decedent here. The defendant also admitted being awake since 4 in the morning the previous day. This crash occurred at approximately 2 to 2:30. The following night, which by my math would be about 22 hours that the defendant had been awake. While the court did not hear testimony as to specifics of how lack of sleep can affect an individual's driving, I think the court knows and is plenty aware that sleep is incredibly important to being able to maintain concentration, be able to maintain a safe driving posture or mental posture. And the defendant nevertheless got behind the wheel and failed to do so, even though he knew that he was probably sleep deprived at that point. Finally, the court heard testimony that the defendant may have been on his cell phone. He did not admit to being on his cell phone. I'm a little concerned that he was unable to say he was not on his cell phone. And he said, well, he may have been on his cell phone. Certainly, that's not beyond a reasonable doubt, but I think it's a fact for the court to consider when it goes towards the overall mentality of this defendant. It's the people's position that he knew when getting behind the wheel, when he was operating the vehicle at 90 miles an hour at 2 in the morning on a dark road, that was wildly unsafe and with willful and wanton disregard for the safety of persons or property. I would ask this, and I would move this court to bind over on the information. Thank you.
Response.
Yes, the people have not met even the low threshold to show that Mr. Folk was driving more than simply careless. The test, I want to make a correction that the people indicated defense testimony. There is no defendant's testimony.
is alleged to have made statements to officers that we are disputing the exact precise nature of those statements, they are contested. So understanding that the court is obligated to consider the evidence in the light most favorable to the people. But I just think that's an important correction, that these are not.
Who's that? I have to do what? You're saying I have to view this in the light most favorable?
I'm sorry, maybe I was saying, I was trying to say, even if the court is viewing this in the light most favorable to the people, there's no sworn testimony. The prosecutor indicated defense testimony, and there's no testimony here. It's statements that he made to an officer. Of course, I'm disputing the credibility of those statements. That is the evidence that the people are relying on. There's no external objective indication of what the speed was, exactly what was happening. Speculation is not enough. Case law is very clear that speculation as to whether he may have been on his phone or he may have done that is not enough to withstand their burden. 3 beers at a Tigers game at 6 p.m. does not indicate what the people are assuming.
Well, the court will take judicial notice that the Tiger game started at 7:15, so it's 6 p.m. But go ahead.
Well, I had thought that he indicated he drank the beers before the game begun. But again, that is one of the issues in this case. They're using his interview as the basis of all of the evidence against him, is his interview with police, which obviously we have a lot of issues.
What do you mean by that?
His statements that he was driving and that he was consuming alcohol and that he may or may not have been on his phone at the time. That these are pieces of evidence that the people just cited in their argument for bind over. And we contest that they are legally sufficient to bind this case over on the charge of reckless driving causing death. Your Honor, I believe this is a textbook case of intervening superseding cause. When you have an unexpected pedestrian who it's undisputed that pedestrian, the ambulance driver, who was the sole eyewitness that testified for the people, indicated he was acting erratically. She indicated that she locked the doors because he was, and I highlighted her statements today, but she indicated he was, scroll down to where I wrote down her statements, that he was, running up to their vehicle and he was on the shoulder running towards us, holding something in his hand. And she locked the doors to the car. I mean, that is significant that they didn't think this was a person who they were trying to reach out to give medical. They actually locked the doors. And one of the other issues I want to highlight is she testified that she heard tires screeching before the thud, which indicates, strongly suggests that the brakes were applied and then there might have been a collision, which is the textbook, I think, break in the proximate cause analysis. And case law is clear. I mean, the jury instruction itself indicates that if there is intervening, superseding cause, proximate cause could be in dispute.
What
and that
arguing is the intervening cause?
The individual being on the side of the highway on cocaine, running towards cars on the highway at 3 a.m.
He's not in the roadway.
I'm sorry, on the shoulder of the highway.
And so that's the intervening cause.
Yes.
Okay.
And I think case law is pretty clear that the criminal standard for proximate cause is different, of course, and more than a factual cause and more than the direct causal connection than the tort concept of proximate cause. I know I don't have to go into this with the court, but it is proximate cause in the criminal context is specifically designed to prevent criminal liability from attaching when the result of the defendant's conduct is too unnatural or remote. That's exactly what we have here.
How is his conduct unnatural or remote?
Your Honor, my argument is to have a naked individual on cocaine on the shoulder, immediately within a couple feet of the shoulder, not near a car, there's no evidence that this behavior was natural or foreseeable or reasonable. The only evidence that the people have presented through their own eyewitness and through their officer in charge, who indicated that he received 5 911 calls about the erratic.
I know, okay, fine, but you're ignoring certain facts if you're making this an intervening cause type of case, aren't you?
Your Honor, that is one of my arguments against Feinberger, is that the people have to meet at every element, and there's no proximate cause here. They have not met that element. Even if they meet all of the other elements, even if this court is convinced that there is evidence of a factual cause, that there's evidence that Mr. Folk was driving the vehicle in question, which of course, we would argue against, but even everything else, I don't believe that there is any evidence of proximate cause. And so I don't believe the court can bind this case.
When you're saying that there isn't any evidence of proximate cause,
there's not enough evidence, excuse me, legally sufficient.
What do I do with the lights on the ambulance with your argument?
Frankly, Your Honor, it helps my argument because it provides the reason for a brake. And so that is
a brake in what?
The vehicle braking, which is what led to the accident.
So the very fact that a driver must have their vehicle under control, I'm just trying to follow your argument, at all times, and that there is an ambulance or emergency vehicle with their lights on, is the intervening action that led to this?
No, Your Honor, the pedestrians, that's the intervening. The ambulance lights, that's not, just to clarify, the ambulance lights could, I think it supports my argument in that lights on a curb, and the court has the map. I actually printed out for the exam, but the court has the map. This is on a curb. So ambulance lights on a curb, a car braking, and having an individual within feet of the line on the side of the highway, not farther back. I mean, the ambulance driver herself said he was within a couple feet of the white line. He was right there. And so that is unnatural. It's not foreseeable. And that is the intervening superseding cause.
Why would it not be foreseeable if I see lights on the road from an emergency vehicle that there would also be people?
It's foreseeable that there would be people in a manner consistent with rendering aid. But
I buy your argument. Well, right. But if I buy your argument, which really isn't making much sense to me, but if I buy your argument, that means every time an emergency responder stops on the side of the road, activates their lights, a driver potentially could hit, say, a police officer or first responder of any type, but it's not foreseeable. You're arguing that it's not foreseeable that there would be a person out there.
Can I clarify? My argument is the behavior, and this is exactly why I was trying to get into the details of the erratic behavior. Police officers, ambulance, they behave rationally. They are lifesavers. They don't run across.
Walk on the side of the road all the time and respond.
Your Honor, the issue here is we don't have any.
You've argued foreseeability. I'm trying to grasp that notion of foreseeability. if I'm driving down the road and I see emergency lights from an emergency vehicle, it is foreseeable that there will be people.
People, sure, but not necessarily people who are on cocaine behaving erratically. I mean,
I don't know what they're doing. But it isn't. You're saying it's not foreseeable that there would be a person there. That's really what you're arguing, regardless of what their behavior may be, because they're still off the roadway.
Your Honor, to the extent that that was not my intention to be my argument. My argument is in this specific case, given that there is evidence, there's undisputed evidence that the individual was acting erratically on cocaine.
So how do you make the specific argument that it's not foreseeable, but only limited to the facts of a particular case? Because that is counter to the notion of foreseeability.
Your Honor, the issue here is we don't know what the actions were. If it was a police officer or if it was someone who was there, they would be able to say, this is what the person was doing. We don't have that here. And I was trying to get into some of the 911 calls.
Yes, we do. We have the testimony of the view of the emergency responder.
So obviously the court is, is more aware than I of what she said, but she did testify that she said, he's charging at us. He could be a danger to himself, others. He was running with something in his hand.
But then he's running away at some point.
Right.
And then the vehicle hits it.
Right. And she, Your Honor, my argument is it's the people's responsibility to put forth the specifics of if they're accusing and they're choosing to charge Mr. Folk with this, what was happening that led to this accident. And my argument is the specifics that she testified to, in fact, raise more questions than it provides answers as to how this person.
You're all over the place. Because if you're arguing proximate cause and foreseeability, then I'm not following that. Because part of that argument is if I see emergency responder lights and I'm driving a vehicle on a roadway, is it foreseeable that there may be people? You're obviously arguing that it's not.
It matters what the people are doing. It matters their actions and where they are and what they're doing.
You know what? So obviously you have an argument to make. I'm going to take a brief recess. I'm going to let you get your argument together and then come and give it to me in some cogent way that maybe I can understand what the heck you're talking about. Because right now I don't understand what you're saying. Court's in recess.
All right.
And I'm driving a vehicle.
Clifton Bush Jr. Good morning. Are you Clifton Bush Jr.? Mm-hmm. And Mr. Bush, were you able to get a lawyer hired?
Mm-hmm. Yeah.
You hired somebody?
Oh.
You did not hire anyone? Okay. Did y'all talk to some lawyers?
Yes, ma'am.
You did? Are you working? Okay, so Mr. Bush, I'm gonna have you fill out some paperwork this morning. You have some family members with you. All right, so I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Y'all need to fill it out accurately and completely. Don't leave it blank. If something doesn't apply, make a notation of that, and then I'll take a look at it. You're gonna swear under oath that it's all true and correct, so make sure you fill it all out right, okay? You'll step in front of the clerk on the end. She'll give you that paperwork. Lance Anthony White. Good morning, sir. Are you Lance White?
Yes, ma'am.
And Mr. White, this is your initial appearance in clause number 26, DCCR 0803. You're charged with a third-degree felony offense of unlawful possession of a firearm by a felon from October 3rd of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Speak up, please.
Working homes and I pay my lawyers, but I haven't been able to.
All right, so what I'm going to do, Mr. White, is reset your case about 30 days or so to give you some time to see if you can get someone hired. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me those names of who you've talked to so I know you're trying, and then we'll discuss your options. Yes. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand?
Yes.
All right, you'll step in front of the clerk. She'll give you your reset notice. Daryl Albritton. All right, sir, you're Daryl Albritton.
Yes, I do.
Did you get someone hired?
Still looking, but I did what you told me to do, the 401k thing. Yeah, then.
Oh, yeah, I'm sorry.
Yeah, and I got another one, with a company called Fidelity. So I got 9. So altogether it's like 3K or something, but I'm waiting on my ID. So I can't do nothing taking my ID.
Have you already gone to apply to?
I already talked to the people. They just waiting on my ID
Your
in the mail.
Okay, so you've already got your ID coming.
Yes. So I'm just waiting on that.
Any idea how long that's supposed to take?
No, man. I don't know how long it's gonna take, but you know.
But you're working, right?
Yes, but I ain't go to work for a week because I had transportation problems.
No, but you've been coming here for.
I know, and I've got a lot of things going on outside of here, outside of work, but I'm gonna get it handled though.
Well, you were supposed to get all that done in about a day.
I'm sorry.
Well, it's. The thing is, I don't think you're going to, I'm going to have you fill out some paperwork this morning, but I don't think with your job that you're going to qualify for a court-appointed lawyer. I'll take a look at it. If you do, fine. If not, then you and I are about to have a serious conversation about you getting this stuff taken care of.
Yes, ma'am.
Step in front of the clerk, fill it out accurately and completely. You're going to swear under oath that it's true, right? Kevin Edmondson. Good morning. You're Tevin Edmondson. And Mr. Edmondson, were you able to get a lawyer hired?
I was coming this morning to ask the court if I could leave like at least another week or two because I had got hit by a car and broken my knee. So I didn't have no movement. I had just been stuck in bed. And, I got an excuse, but I'm gonna start moving around today so I can go try to something to bring it home. I got a call this evening, but I do have my money saved up. I was just trying to
Okay.
And I get a little more.
Sure, thank you. And obviously I can see that you had something happen. I'm going to do a normal reset. So that's 30 days. That should give you plenty of time to get someone hired. If you do bring that reset to them, if for some reason you're not going to be able to, make sure you talk to at least 3, bring me those names, and then we'll discuss your options. All right, step in front of the clerk.
Thank you so much, Judge.
Yes, sir. Lylvester Hassan. Good morning, sir. You're Lylvester Hassan. And Mr. Hassan, were you here before?
Yes, ma'am.
Okay. Were you able to get a lawyer hired?
I talked to Mr. McNally, and this is something we agreed upon. I didn't need more than 30 days to get my.
Okay, but you're planning on hiring him?
Yes, ma'am.
So I'm going to do one more reset, Mr. Hassan, to see if you can get Mr. Macon hired between now and that next court date. If you do, just bring the reset notice to him. If you're unable and you don't think that's going to work out, then you need to talk to at least 3 others and bring me those names, okay?
Okay, how do I do like the court appointment?
Well, if you,
In town.
so if you have the money to hire someone, then you're required to hire them. And you don't know that unless you talk to enough. So if you can hire Mr. Macon, great. If not, if that's too expensive, then you need to let me know, bring the names of who you've talked to when you come back. And then I'll see about you filling out the paperwork, and I'll take a look at it to see if you qualify for a court appointed lawyer. But I want you to attempt to get him or someone hired first. Okay. All right. Step in front of the clerk right here. Christy Johnson. Good morning, ma'am. You're Christy Johnson. Ms. Johnson, were you able to get someone hired?
Well, I remember I said I was gonna go with Mr. Marvin court appointed attorney, but I'm gonna pay him with cash. So I was looking for him to get the job. So why I can pay him.
Okay.
And I'm in a job and we go to pay him 240. So
To Mr. Lewis's today?
well, to the job.
Oh, okay.
I'm trying to call Mr. Lewis and I can't never get in contact with him.
Well, that's,
My main thing was getting the money to pay.
so you start working today?
Yes.
Where are you going to be working?
Waffle House.
Okay. And you think you'll be able to get him or someone hired if I give you another reset? So I'm going to reset your case one more time. You've been here a few times, so it's going to be time for you to get someone hired. If for some reason you can't hire him or someone else, when you come back, bring a pay stub as well, so that if you fill out that paperwork, I can take a look at that and know exactly what you're making and whether you qualify for a court appointed. Okay. Okay.
Yeah.
Step in front of the clerk. She'll give you a reset notice. Desiree Doucette. Good morning, ma'am. You're Desiree Doucette.
Yes.
And Ms. Doucette, this is your initial appearance and cause number 26 DCCR 0757. You're charged with a 3rd-degree felony offense of deadly conduct, discharging a firearm. And that's from May 20th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Not yet. I mean, not yet, but I'm sitting and talking to the few lawyers.
Okay.
I think I may have spoken with one and may go with, but right now I'm just trying to figure out
Sure.
payment options.
Okay, so what I'm going to do, Ms. Doucette, is reset your case about 30 days to give you some time to see if you can get someone hired.
Yes, ma'am.
If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. I'll charge different amounts, have different payment plans. Bring me back the names of those you've talked to. So I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would have to go back to jail. You understand? All right, step in front of the clerk. She'll give you a reset notice.
Oh, I'm sorry. Thank you.
Javon Johnson. Good morning, you're Javon Johnson. And Ms. Johnson, were you able to get someone hired?
I actually am going, it's Maggie Holmes, I made her at 12 today. The gene that I was back and forth out in the hospital, I hadn't been able to work. I do engines and rebuild them. I hurt my back today. She's the only one that I found that's a little bit cheaper than I can actually.
Okay, so you'll be able to get her hired, if I reset her.
Yes, ma'am, she's willing to take so much for me to.
All right, so what I'm gonna do, Ms. Johnson, is just do about a 2-week reset. Bring the reset notice that you get today to her, so she knows when that court date is, and then she'll let you know if you need to be back on that date or not. Okay, step in front of the clerk, Brittany. Miracle Oville. Good morning, your Miracle Oville. Ms. Oville, did you get someone hired? You didn't? Who'd you talk to? Speak up, I can't hear you. You didn't speak up. Talk louder. Who? Dunham and Jones, okay. Who else?
I can't remember. I just have to take this.
I can't understand you.
The other guy, I can't remember. I can't remember.
Mr. Parker, can y'all hold it down? I'm having a hard time hearing.
So the other guy, I can't remember. I just have to take this. I don't remember his name. I did speak with him. We kind of went through like.
Why didn't you? So you've been here before. Why didn't you write all that down and bring it to me like I asked you to?
I did, but I had it in my phone. I didn't transfer it to paper. I didn't have to.
Well, where's your phone?
It's right in my phone.
Okay, tell me. I want to know the 3 lawyers that you talked to that I asked you to do.
Okay. It was the Jones, technically I talked to 2.
Yeah, you're just mumbling.
Technically, I talked to 2 of the people at Donovan Jones.
You talked to 2 different lawyers there?
Yeah, I didn't realize that. One of the name was Matt Shanks. The other one.
You actually went and visited with them?
Mr. Shanks.
Okay.
Because remember, I don't live out here, so I couldn't.
Well, obviously I don't remember. I do this every week with my courtroom this full. Okay, so you've talked on the phone with.
Yeah, and that's who I was mainly pretty much moving forward, since I had talked to both of them.
Okay.
And we had they pretty much gave me basically a fair rate and stuff like that.
Okay.
So
when are you gonna get them hired?
I want to say hopefully soon. Before.
What is that? I don't know what that means.
By the 31st.
Okay. July. I'm gonna reset your case one more time. You need to get someone hired before that next court date. If it's not going to work out with them or one of those people at Dunham and Jones, then you need to talk to at least 3 others, and you need to have those names ready on who you actually spoke with when you come back. Okay. Step in front of the clerk. She'll give you a reset notice. Robert Wayne Simon. Good morning, you're Robert Simon.
Yeah.
So, Mr. Simon, you've been here before on 2 cases, and you've been indicted now on a new offense. Well, it's a new indictment, but it's an old offense. So that is cause number 26 DCCR 0720. You're charged with the state jail felony offense of possession of a controlled substance from August of 2024. So where are you on being able to get someone hired on your causes?
This is what I've got, Your Honor. I have tried my best, hire an attorney.
Okay.
Done whatever you asked me to do. I've done all of it. I can present that for you now.
Who'd you talk to?
Trying to hire Ralph Pembroke. As of now, it's the money situation. I'm trying to pay the bond, the bills, and him at the same time.
Are you working?
Yes, ma'am.
Okay. Because you've got that new indictment, I'll give you one more reset. I'll also allow you, if you want to fill out some paperwork this morning to see if you qualify for a court appointed. I mean, it depends on what your income is, but I'll take a look at it if you want to do that.
I do. Problem is, I'm waiting on my wife to show up and get her to fill it out. I'm really dyslexic. I can't see things.
Oh, is she on her way?
Yes, I saw
Okay.
things backwards. So if I can't get her to fill it out for me. As soon as
Okay.
she gets here.
Well, if she's on, I'm gonna have you get the paperwork from the clerk and then y'all need to fill it out accurately and completely. You're gonna swear under oath that it's all true and correct. So make sure you don't leave everything, things blank, but if it doesn't apply and things like that, and then I'll take a look at it. All right. Step in front of the clerk on the end. Jasmine Jaquette. Good morning, ma'am. You're Jasmine Jaquette?
Yes, ma'am.
And Ms. Jaquette, were you able to get someone hired?
So I have a couple of people I was already working on this homes. I reached out to this Lewis and this Lloyd Perezzo, but I just have some stuff going on right now. I'm gonna just go ahead and get the court appointed so that I can get stuff moving, because I don't know how long it'll take.
Are you working?
Yes, ma'am, I'm working now.
Okay, well, you don't get to just get a court appointed. That's the whole point, is that if you're working, I expect you to try to hire someone. Where are you working?
At the Port of Bowman. So it's like a temp, it's like when they have work, then I work, I get picked, but it's not like a day to day.
Okay, so I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely, because you're gonna swear under oath that it's all true and correct, and then I'll take a look at it. Step in front of the clerk on the end, she'll give you that paperwork. Oh, you know, that sound is. That sound is me getting emails. For some reason, when I get an email, it's making a sound, because I notice I'm getting, that's what it is. It's like a notification. Well, then I won't know how to get to it, so I don't know why. Anyway, we'll figure it out. It says. See, Judge Walker, you've got Aaron Shutley.
Judge, can we hold that for 1 second? Just want people to know on our way down.
Sure. See, Mr. Wasserstein, you've got Guadalupe Reyes.
Yes, sir.
Yes.
Guadalupe.
Good morning.
Morning.
Morning, Judge.
Morning.
Morning, Judge. You look good.
That's TRN sound. All right, sir, you Guadalupe Reyes?
Yes.
This is 25 DCCR 1422. This was the final reset, so there needs to either be plea papers or a rejection. What's the announcement?
I'll show him how to do the rejection. I think he was, go ahead, sorry. Judge, I'm going to ask for another setting. I know it's in writing and you advised us there wouldn't be any more settings. Since the last setting we had, I've got an investigator. Met with my client a few times at the office. There's some things I'd like to look into before putting it on the trial docket. I don't know if you'll give us one more setting. I would ask for 30 days, just that'll.
So typically when I say final, it's final, but this is going to be the last final. Okay.
Thank you, Judge.
So this will be, truthfully, you've got to get everything taken care of
Yes,
before
sir.
that next court date. Make sure you stay in touch with your attorney. Y'all go over everything, whatever the state's offer is. Either you come back, you take that offer, or we put your case on the trial docket.
And he's done that about the offer. I think, Judge, he's gotten all discovery. He did ask me this morning about an extension to have his investigator look into some things. I don't have a problem with that because he's taking care of everything else.
Perfect. All right.
Judge, and
We'll see.
Mr. Nichols has told my hand about if I need to do a rejection,
Perfect.
how to use the tablets.
Okay, well, we'll get you taken care of next time, but we'll see you then.
I appreciate it, Judge.
Yes, sir.
Thank you, Mr. Nichols. So.
He's gonna roll cell phone or the sign glass.
See, Mr. Radford, you've got Marquise Berry.
Yes, ma'am. Fair.
You need to set that on the trial docket.
Did you do a rejection?
I think she's already done, because I'm the trial counsel that was appointed.
Has there been any change in?
No, ma'am.
All right, ma'am, your Marquise Berry. And this is 25 DCCR 0882, and Ms. Berry is charged with aggravated assault with a deadly weapon. It's like back in March, there was a rejection of a 10-year term in prison, and you want to continue with that and go forward with trial with Mr. Radford. All right, we'll get it set on the trial docket. I do want to make sure, Ms. Berry, that you understand that after today, once your case is on the trial docket, I will not accept this plea agreement unless there's something that comes up that your attorney or the district attorney doesn't know at this point. Otherwise, if you change your mind, you can enter a plea open to the court or to some other plea agreement. You understand? Okay, we'll get it set on the trial docket. Thank you.
May I speak?
Yes, sir. Aaron Shetley, Ms. Melfino, and Judge Walker. Morning. All right, sir, are you Aaron Shetley?
Yes,
And Mr. Shetley's case is set, it's a pretrial, set trial to begin with jury selection next Monday. What is the announcement?
Judge, I have spoken many times with Judge Walker about this case. I know that it's obviously getting older on the trial docket. I had also let her to know several months ago that I was likely to be out next week, and I let her know several weeks ago I will be unavailable for court. I apologize about that. We are still working toward a possible resolution that may involve a jury trial, but that's something that Judge and I would like to possibly discuss with you a little bit later. But that is my situation for my two trial cases next week.
Okay.
I asked that they.
And we
stay
left
on-
them on today just in case. We're going
Yes,
to make
because
sure that there was anything that might get worked out. But if it's not going to get worked out today, any objection to that getting reset?
If she's not going to be here, we're ready.
Okay.
And I did let Judge Walker know.
So we'll just reset it on the next available trial docket. If something works out between now and then, please bump it up and so that we can get it taken care of before that date. Otherwise, we'll get it taken care of the next court day because it is definitely one of the older ones on the docket.
Thank you.
So-
And I've also spoken to the misdemeanor prosecutor who's handling that, and I think
Okay.
we'll try to take care of everything.
All right, stay in touch with Judge Walker. He'll let you know when you need to be back. Thank you.
Oh, well.
See, Mr. Rojas, are you ready on William Bonilla?
Yes.
Good morning. Are you William Bonilla? Good morning. This is, good morning, Mr. Rojas. Clause numbers 25 DCCR 0719 and 25 DCCR 0174. And what is the announcement?
Yes, I think our plan is to enter pleas to the motion, come back with the punishment hearing, and then after that, we'll see what happens with the felon defendant case.
Oh, okay. One of them's, are
The
they?
motion, it's a motion to revoke on a misdemeanor. EWI.
So, and so what are you guys going to do with the new case?
The motion is based on the new case, so depending on what you do with the motion, I think eventually we're going to plead it, but I want to see what happens punishment wise on the motion before we do that. Sure.
Mr. Bonilla, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
And thank you. Will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. Bonilla, in cause number 25 BCCR 0174, I have a motion to revoke your community supervision. Shows that you were placed on probation April 14th of 2025 for the Class B misdemeanor of driving while intoxicated. That was a 180-day jail term that was probated for 15 months. Is that correct?
Yes, Your Honor.
It alleges that you violated your probation. Count 1 alleges that you committed the new offense of evading arrest or detention with the use of a vehicle, May 10th of 2025. And is that true or not true?
Your Honor, before he answers, may I move to orally amend that count to read that the defendant committed the offense as opposed to was arrested for the offense, so that it lines up or matches the MPRP or the
Thank you.
conditions. No objection.
Okay. All right, so count 1 now alleges that you committed the offense of evading arrest or detention with the use of a vehicle, May 10th of 2025. And is that true or not true?
Not true.
So we're gonna have to come have a hearing with,
That's just a matter of you watching the video and there's all. But yes.
I mean, you'll have to have an officer come to
Yes.
prove it up. Have y'all watched the video?
I have.
Okay.
We have, yes.
Okay. Count 2 alleges that you failed to immediately report to the probation officer that arrest from May 10th of 2025. And is that true or not true?
True.
Did you enter your plea of true to count 2 freely and voluntarily?
Yes, ma'am.
And because count 2 is actually true. All right, then I'm going to find that you entered your plea of true to count 2 freely and voluntarily, find that count true, find sufficient evidence to not find you guilty, to revoke your probation. I'm going to reset your case for sentencing. And it sounds like we just need, unless there's some agreement that if it's mainly just the video, if you guys agree that he can present the video without having an officer having to come lay that foundation, great. Otherwise, I would think still in 11 o'clock with just one witness would be plenty, correct?
Yes, ma'am.
All right,
Yes.
y'all discuss that and then I'll get an updated pre-sentence report and we'll see you back at sentence.
All cell phones out of sight during the proceedings. Like, don't let me see them. You put that phone away.
They're recording.
I don't think so. They're going to talk on.
Mr. Rojas, you have David Calderon.
It's Calderon.
Good morning, sir. Are you David Calderon? And this is 24 DCCR 1428. Mr. Calderon is charged with unauthorized use of a vehicle. And what is the announcement?
Judge, we're asking for another announcement document. We do have a discovery in the offer. I have relayed an offer to Mr. Calderon. However, it was the wrong offer. Somehow my offers got mixed up in the file. So now
Okay.
I need more time to go over the correct offer and give him time to look at all that. So no objection, Judge.
All right. So I'm going to reset it one time. I know you were just recently appointed, but Mr. Calderon had to come here quite some time. So the case is very old. So if you can try to get with Mr. Rojas, make sure you go visit with him before the next court date so that we can get an announcement. All right. You're free to go. Jamie, Carol, Mr. Rojas? Good morning, ma'am. You're Jamie Carroll. This is 26 DCCR 0286. Ms. Carroll is charged with injury to a child, elderly, or disabled individual. And what is the announcement?
Judge, I spoke with Ms. Carroll on the phone briefly last week. We haven't had a chance to go over all the discussion. I can give you that now from about the, you can do that.
Any issue with something?
No, Judge, I've sent two alternative offers to Mr. Rojas.
So, Ms. Carroll, I'm going to reset your case about 30 days. You need to make sure and call, make an appointment to go visit with Mr. Rojas. So you can go over everything that he has, and we'll get an announcement at the next court date. Don't wait till right before that court date. Make sure you call him, go see him plenty of time before that, okay? Yes. All right, free to go. Gabriel Pena, Mr. Rojas. Good morning, Ms. French. Good morning. Good morning, sir. You're Gabriel Pena.
Yes.
And this is cause number 26 DCCR 0064. Mr. Pena, you're charged with the third-degree felony offense of failure to comply with sex offender registration requirements. And that's from September 27th of 2025. Your indictment alleges that you were previously convicted of indecency with a child by exposure, third-degree felony, December 2nd of 1999. That after that was final, you were convicted of failure to report a change of address, a third-degree felony, May 22nd of 2014. And what that means, sir, is that if you go to trial and you're found guilty, the minimum punishment would be 25 years up to 99 years or life in prison. Do you understand?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. I'm sorry, no, I don't. I have a document entitled plea bargain rejection. It shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 20-year term in prison. You have every right to reject that, have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are. And do you understand all of that? Thank you. And so do you want to reject that offer and have your case set for trial? All right, I'll get that taken care of. Mr. Pena, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint a new attorney today who could begin preparation for trial a little quicker. Is that okay with you?
That. Sure, I could. Answer that. Is it to my?
To your benefit? Is that what you're trying to ask? So it's really up to you. If you want to keep Mr. Rojas, then he can prepare for trial and get ready. Otherwise, I'll appoint a different attorney today and they'll get prepared. Mr. Rojas is just here a lot, handles a lot of cases and a little busy, but it's up to you. If you want to keep Mr. Rojas, that's fine.
Which?
It's completely up to you.
With your. Opinion.
It's really, yeah, it's really up to you. Mr. Rojas is fine either way. So if.
And we have a few minutes, maybe pop up.
Yeah, sure. And you can just let me know and then I'll either y'all visit for a few minutes and then he can let me know what your decision is. Okay.
I'm so sorry, excuse me.
Darius Sparks. Good morning. Are you Darius Sparks?
Yes.
And Mr. Sparks is charged with assault, family violence by impeding breath or circulation and clause number 25 DCCR 0754. And what is the announcement?
Judge, I think we have a resolution this morning. May I first permission have the name?
Ms. Grady testified.
Honorable Jason, maybe seated. Back on the record in the case of the People versus Folk. Jackie, you may continue with your.
Thank you, Your Honor. I want to clarify that my argument is not that Stevens just presence at the side of the highway or the roadway was the superseding intervening cause. Ms. Grady testified that the decedent ran towards her vehicle in the minutes leading up to the accident, such that it caused her to lock the doors and think that he could be a danger to himself or others. So this is different from any situation in which any medical or police or any other person is just merely on the shoulder of the highway or standing on the shoulder of the highway. In those cases, the actions of those individuals likely, we wouldn't have testimony that someone was running towards incoming vehicles. And I just also want to highlight that she and the officer specifically referenced safety protocols and procedures in place to entail safety when there is an ambulance on the side of the highway. So we heard specifically testimony which involves preventing cars from traveling in the lanes nearby, restricting travel on the highway for this reason. So that would be my argument, Your Honor.
Anything additional?
Briefly, Your Honor, touching on 2 points defense counsel made. Defense counsel rested in part her argument that the defendant or the decedent was acting erratically. I believe the language was charging at the ambulance. My recollection of the testimony from Miss Grady was that the defendant was off the lane of travel on the shoulder at the time that this crash occurred. So to any extent that he was acting erratically in the place where the defendant shouldn't have been driving regardless of what he was doing, because the defendant should be maintaining the lane of travel, not driving into the shoulder. Defense counsel also, I believe, made an argument before we took a recess that there's no evidence other than the defendant's statement to Sergeant Bowden about how fast the vehicle was going. And while certainly there was no mathematical calculation put before the court, I believe the testimony was that the decedent was found, I believe it was about 10 yards off the road, which then had several more feet from the fog line to the end of the pavement. And that itself was, I believe, the Ms. Grady testified about 100, 150 yards down the road. So moving that far from the early indicator, it does not give an exact number, but it corroborates the defendant's own admission to Sergeant Bowden that he was going 90 miles an hour approximately. For those reasons, for the reasons I originally stated in my motion for bind over, I would again move this for bind the defendant over on the information.
Okay. Okay. All right. Let me just say at the beginning that I think that maybe the decedent's family back there, and I've been watching the defendant ever since sitting on the bench, the cases that defense of what might be negligent homicide, but they are always difficult because a lot of times in cases you have good people, you have bad people. But in these cases, you can have good people all around, and a bad thing has happened, and it's not. It just is what it is. With reference to the arguments in this case. Let me just say, I think, given the testimony in this case with reference to count 2, the failure to stop at an accident scene where there was a death involved, that being count 2, that the people have indeed sustained their burden on count 2. The testimony of the HVA responders, Ms. Grady, particularly as to the vehicle going past the ambulance. At that point, then staying there approximately 30 seconds and then taking off, I think substantiates that charge. With regard to the charge of reckless driving causing death, I think certainly that there are factual issues involved as to what the defendant's vehicle was doing at the time. I think the location is important. I think that the people, as it relates to that charge, have also sustained their burden. The court, and I want to make it very clear, the notion of superseding or intervening cause and the foreseeability of whether or not this individual would be here is not limited to this individual being there. Did he come across a circumstance which should have been foreseeable for a driver on a highway? Take all of that as to a determination of foreseeability and causation. One has to remember that the ambulance is there. I had specifically asked Ms. Grady whether the lights were fully activated. The lights are fully activated. That is consistent with the statement that the defendant gave Trooper. For whatever reason, he assessed the lights, at least according to what he told the trooper, as being on the other side of the road. And then the accident happens. I'm here to make a probable cause determination as to whether or not the defendant, there's probable cause to believe that he was driving recklessly, and that in driving recklessly, that caused a death. The concept of a reckless driving is driving with a willful or wanton disregard for the safety of persons and property. I think that when you have an emergency vehicle, you're traveling, by the defendant's admission, he was doing 90, which would be 20 miles per hour over. It's even more so in terms of an excessive speed where there is an emergency responder's vehicle, because one is required to slow to a point that didn't happen. I think there is certainly enough to believe that the defendant was driving recklessly, particularly since his vehicle struck the decedent and then had enough force and momentum that he could not control that vehicle, and it continued past the ambulance that was there to ultimately try to deal with the individual on the side of the road. Maybe the argument of proximate cause, there might be a factual development that would lead that to be maybe addressed in circuit court. But from a factual standpoint, the court, in looking at all of this, believes also that will have sustained their burden and would also bind the defendant over to stand trial on the count of reckless driving causing death, or taking all of the factual circumstances into account during the course of the testimony.
We would wait for a reading, stand mute.
And then, having waived formal reading, standing mute, the court will enter a not guilty plea as to both counts. Pretrial in this matter will be set
August 11th at 1:30 with Judge Cook.
August 11th, 2026, 1:30. Anything as to bond?
Nothing from the people, Your Honor.
No, Your Honor, thank you.
Bond will continue.
When appropriate, may I approach to sign the information?
Yes, sir. Mr. Bellinger, can I see you in back, please?
Yes, Your Honor.
He needs to sign that. Those are his exhibits. Before I talk to Bellinger. Are they ready?
But
Ready.
Are you ready?
in that when you allowed them 2 weeks to contact the alleged victim, my client was in jail then and remains in jail now. Now, the reason he's in jail is because of this charge and he's on parole. The fact of him having this charge constituted a parole hold. So what happened, Judge, is that the court, because the court was going to set it for 1 week, I'm sure you remember, but Mr. Cook said, okay, I need more time. The court said, okay, Mr. Cook, 2 weeks. So they've had 2 weeks to contact this alleged victim. They have not done so. In conversation with Mr. Cook, he's saying, well, okay, well, if it's going to be a jury trial, then final settlement conferences are in August. So apparently what Mr. Cook is saying, even though the court graciously allowed them an extra week to contact the purported victim, he's comfortable with having my client stay in custody for.
I don't think that that's, and Mr. Mack, that I don't think, as I'm recalling everything, that was ever Mr. Cook's position. I mean, he wanted to contact the victim. I think he understood and appreciated the entirety of it. I think we all did. Quite frankly, Mr. Cook may not have been under an obligation to do anything. And if you wanted a jury trial, then you get set when it gets set. I'm sure he was going to try to use his best efforts, but.
So, Your Honor, what I'm asking the court is that in light of the fact that my client is in custody, the court has given the prosecutor great opportunity to contact the alleged victim. So first of all, I'd be asking for a motion to dismiss.
That's going to be denied. This would be the appropriate time. And, you know, Mr. Mack, the problem here becomes, look, these kinds of things happen in DV cases. There's not a doubt that alleged victims disappear, then appear and do whatever. You know, that happens. So what are we doing on this case?
Your Honor, if the court will not entertain the motion to dismiss, I asked the court to.
It denied.
Okay, if the court's denied the motion to dismiss, Your Honor, my client informs me that I believe he's under a $20,000 cash or surety bond. My client will exercising his right a jury trial. And in light of that fact, and the court's protocol is to only have jury trials every other month. So in other words, the next jury trial.
Not my schedule. That's set by other people. I'd have them every day if I could.
Yes, sir. I understand. So, Your Honor, so in that regard, my client is requesting, he has a job, children to support, one child with mental illness. So what my client is asking the court to do, would the court consider reducing his bond to a $10,000 bond, cash or surety, with a tether? That more than protects the interests of society in general, or the protection of the alleged victim in specific. It would allow my client, if he can convince the parole officer to lift the parole hold, which we don't know, but it would certainly give him an opportunity, Judge. And that's all he's asking for, an opportunity.
That's the other thing. Yeah, I love it when we get up here and it was half the story, because I think the other half of that story about the adjournment was contacting parole to figure out what they were going to do. I haven't heard anything about that.
Yes, he did contact. I've been in touch with parole officer myself, and the court saying depends on what's happening with this case. that will determine the, whether there's going to be a parole violation charge or not. So everything is up in the air. And all I'm asking, Judge, is to please give the man a chance to maintain his employment and look after his family.
But what are they going to do with it? Because if he gets out, that's part of the problem. If I give him a bond, if I gave him a PR, I'm not saying that I would, but if I give him a PR, but they didn't just grab him up, hey, what have we done? Oh, that's why they were supposed to be. Both sides were supposed to do something or try to do something. So,
and Your Honor, absolutely correct. And what my client informs me is he does have another place to stay, a stable place to stay, and we'll communicate that with the parole officer. And it's a big if the parole officer would even lift the parole hold, Judge. We don't even know that. But I'm saying you could certainly, and we're asking you to please at least give it a plausible chance of success, a chance of success. The court is well familiar with the GPS tethers, set whatever parameters the court desires. There's no danger to anybody, Judge. And the man can work and help support his family and pose no threat to anyone, Judge.
Mr. Cook.
I want to make sure the record is clear on certain things. It is absolutely correct that at the last pretrial, which to my recollection would have been, I believe, June 1st, if my notes are correct.
Yes.
At that time, I believe defense counsel asked to set the matter for final settlement conference, and the people asked instead to adjourn the matter for a pretrial to give the people an opportunity to discuss with the victim, because by that point, the case was not even, I believe, 10 days old. Right. And we had not had an opportunity to discuss with the victim. At that time, I don't know if I made the representation on the record or if it was just in a conversation with Mr. Mack, but my notes indicate that part of the reason for adjourning was to potentially set it for a bench trial at an earlier date than the August FSC in order to get this case heard as expeditiously as possible in the event that the people were either unaware if they could proceed or unable to proceed. Had confirmation from the victim they would not be interested in prosecution. I am still of the opinion that I want to get this case resolved as soon as possible in a way that is fair both to the defendant and the victim. And to that, I had a conversation with Mr. Mack this early afternoon, morning. I don't remember exactly when, but it was earlier today, where I told him we can set it for the earliest available bench trial date if the court and defense counsel wanted to, in order to get this matter heard before the August FSC. Because contrary to what Mr. Mack stated, I do not enjoy seeing the defendant in custody, and I don't want him to remain in custody any longer than is just and fair. So I would not have an objection to setting this matter for a bench trial. I want this case to be resolved, but I have to take into consideration the victim's wish. We've been given that opportunity and I've not been able to contact her. We have made efforts, but the simple fact of the matter is we simply do not have good contact information for this victim. Having gotten that opportunity, I'm now trying to get this case heard and resolved as quickly as possible, which I believe would be by a bench trial, as I fully expect we'll reach a resolution on that day. But I wanted to make sure that it is clear that I'm not out here trying to get Mr. Johnson to stay in custody as long as possible, that I enjoy a deprivation of his liberty. I'm simply trying to make sure that the victim and the defendant both are heard and respected in these proceedings.
Am I allowed to respond or no?
Well, you can respond. I'm just going to say I agree with Mr. Cook. He's been practicing before me. He doesn't like anybody sitting in jail. And frankly, there are times where he doesn't have a problem with somebody being released, but the court does. And so, Mr. Mack, I get attorneys have to do their job and everything, but, people just be fair to each other. Because he doesn't attribute you representing this defendant as that you want anybody that beats a woman to walk out there. He's not saying that. So, yeah.
Can you consider $10,000?
What am I setting it for?
Well, Your Honor, it would be allowing to be scheduled for a final settlement conference August.
Jury final settlement conference will be set for
August 7th.
August 7th, 2026, 9 a.m. Jury selection if necessary. August 10th, 2026, at 8:30. Both of those proceedings are in person. What I'm going to do, reference the defendant's bond, is I'm going to continue the defendant's bond as it is. If the defense counsel through the parole officer indicates that the defendant would not be taken into custody, basically would lift the hold at this point. The court would consider reducing bond.
All right, Your Honor.
Thank you. Are you almost ready?
To be right with you, I'm not going to use my name, Your Honor. Stand if you need a break, then you.
I do. All right, court shall stand in brief recess.
Thank you, Your Honor.
You will.
All rise.
Raynella Gage called, and to see if she's in the courtroom today, then I can.
Raynella Gage. Yes, ma'am. Raynella Gage. Is there a Raynella Gage? If you'll call the name, please. Raynella Gage.
Robert Simon. No response, Your Honor. Judges, the record may reflect that I have reached out to Ms. Gage. I've sent her multiple letters. She did call back. She was, I returned her call. She was in a meeting that said she would call me back. She has yet to do that. I just wanted to see if she was in the courtroom today, but I do think we have a resolution that this court will allow him to participate in the bid program. But this case to remain pending in case he does not successfully complete that, and a determination of it should dispose of the court.
And how long is that program? 6 months.
Should be no more than 6 months, and we could probably get him signed up the first week of July. We could maybe do a 90-day status check on how he's
I
doing.
definitely want to make sure. So here's the thing, Mr. Sparks, I'm going to reset your case, and what I'll do is I'll do a 90-day reset. But I'm ordering you to get signed up for that tip class at the very first available class. Because this is a great opportunity. Okay. If you take this class and do everything you're supposed to successfully complete it, it sounds like your case is going to get dismissed. You can't get a better deal than that.
Yes,
But here's the thing, if you miss the class or some reason get kicked out of the class or you're not going like you're supposed to, I'm not going to put the case off any longer. It means you're going to be back here facing this case here in court. Okay. So it's very important you do everything you're supposed to. All right. Thank
Judge,
you.
would you mind still admonishing him as to the no contact areas?
Yes. So you have, as part of your bond, you're still on bond now and you'll be on bond this whole time. So you still have to follow all of those rules.
Yes.
And one is that you have absolutely no contact or communication with Raynella Gage. That's in person, that's sending messages, that's any type of communication. Do y'all have a child together or anything like that? Okay, so there's absolutely no reason for you to contact or communicate with her. That would be an immediate violation of your bond. Obviously, the same deal that you're getting right now would be off the table. You understand? Okay, we'll see you back in 90 days. Talk to Mr. Rojas. He'll let you know. He'll get with Ms. Malfino when that class starts and how to get involved in all of that. Okay. Whitley Shepherd to sentencing, Mr. Rojas.
Whitley Shepherd. Whitley Shepherd.
Very good.
Left now on that, let's make sure. Then there is that.
Good morning. You're Whitley Shepherd.
Yes, ma'am.
And Ms. Shepherd was previously in court, entered a plea of guilty to the second-degree felony of aggravated assault with a deadly weapon. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor. Yes, Your Honor.
Are there any additions or corrections?
Not from defense. Not from state, Your Honor.
Ms. Shepherd, when I'm reading through what happened that day, it is one of the most frustrating things. You are out there as a parent at a park where we've been having all these issues with the kids acting stupid with guns and shooting. And there you are with your kids and other kids out there displaying a handgun. I have had some second thoughts about even going along with this plea agreement, because that type of behavior, especially as a parent in front of all of those kids, is unacceptable. That's what's wrong with what's going on in our community right now. Does that make sense to you? Yes, ma'am. So if I do go along with this, I want you to understand how important it is that you follow every rule under this probation, because if you violate any, things could be very bad. And I'll talk about that in a minute. You understand? Mm-hmm. Any reason not to go along that you can tell, Mr. Rojas?
No, Your Honor.
Mr. Nichols. Sorry, I'm reading these other names and hearing sounds, so. You've got two sons, 17 and 16, right?
I'm sorry, so he just
turned 18 yesterday.
Mm-hmm.
And then is the youngest one's a girl?
Mm-hmm.
They all live with you?
Yes, ma'am.
There any other guns in your house at this time?
No.
Your kids in school?
Yes, ma'am.
Where do they go to school?
Yes, ma'am.
All right, Ms. Shepherd, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. I'm going to follow this agreement. I'm going to defer all proceedings, place you on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. That includes that you cannot go to Magnolia Park at 2930 Gulf Street. Can't be anywhere near it. Do you understand? Also, you can obviously not have any contact whatsoever with Myrtle Reggie, Jeremiah Lee, and Soraya Reggie. Do you understand? That's in person, but that's also sending messages or electronic communications or anything like that. You understand? You cannot have a firearm anywhere in your house, in your car, at your work. You are not allowed to be in possession of a firearm, and you can't have one in your home, even if it technically belongs to someone else. You understand that as well. If you do everything you're supposed to on this probation, this is an amazing opportunity because you don't have a felony conviction. And at the end of the probation, you can, if you're successful, the case is dismissed and you never will have a felony conviction. But the other side of that is if you violate any condition of probation, you can be brought back in here, found guilty of the offense. And I have that entire range of punishment to look at, which is up to 20 years in prison. It's not just the 5 years that you're being placed on probation for. It's the whole range between 2 and 20. Do you understand? Mm-hmm. All right, I'm handing you the trial court certification that shows this was an agreement that I followed. And so you waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, ma'am. Luciano Richard. The sentencing,
Yeah. Look up top.
good morning, ma'am. Are you Luciano Richard?
Yes.
And Ms. Richard was previously in court, entered a plea of guilty to theft of property with previous convictions, a state jail felony. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have our own state has such.
Any additions or corrections?
Not from the defense, not from the state judge. We'd ask that the court follow the agreement of the parties.
Thank you, Mr. Coleman. Ms. Richard, I'm going to follow your agreement. I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to defer all proceedings, place you on probation for 5 years. You're ordered to pay a $500 fine, and you're also ordered to pay $220.46 in restitution, and to follow all of the other rules and conditions of probation. If you do all of that, this is an excellent opportunity because you will not have a felony conviction on your record. And at the end of the case, if you successfully complete it, the case will actually be dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition, you'll be brought back into court. You could be found guilty, so you would be a convicted felon, and you could go to the state jail prison between 6 months and up to 2 years. Do you understand? 5 years is a long time. In fact, if you take care of everything you're supposed to, get that restitution, your fine paid off, do your community service, it is very likely that you could get off probation even earlier than that. But that's up to you. You have to do everything right, get it all taken care of early. And then I sign early dismissals from probation all the time. I mean, you have no felony history. There's no reason for you not to get this taken care of and get off early. Okay. All right. I'm handing you the trial court certification that shows this was an agreement that I followed. And so you've waived your right to appeal. If you'll just have a seat here in the courtroom, watch for probation. She's going to call you up when she's ready to go to your paperwork. All right. Good luck to you. And then I'll give you a minute to go talk to Mr. Pena. Mr. Burbank, you've got John Martin. Hearing. That's the third one today. It's okay. I know. Good morning.
Good morning, Your Honor.
Good morning, sir. Are you John Martin? Mr. Martin, and cause number 25 DCCR 0583. You're charged with the third-degree felony offense of injury to a child from March 15th of 2025. And what that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand? And I have here on the tablet a plea bargain rejection that you signed with Mr. Burbank that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 5-year deferred probation, which means it's a type of probation where you don't have a felony conviction. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter that plea. Do you understand? Do you want to reject that offer and have your case set for trial? And is there any reason to believe that offer would change or go down, Ms. Malfino?
Not today, Judge. It's my intention to send out trial notice this week. Mr. Burbank and I have discussed and reviewed CPS records in this case. We do have a plan going forward, or to pre-trial if something were to develop, we'll let you know before that.
Okay, perfect. So unless something changes, like Ms. Malfino said, then typically after today, I will not accept a plea agreement once it's on the trial docket. So stay in touch with Mr. Burbank. If something comes up and you guys get some other information, it works out, we can take care of that well before that trial date. Otherwise, we'll take care of your case on the trial date, okay?
Thank you.
All right, thank you, Mr. Burbank. Yes, sir. Yes.
Yeah, I think, you want to look at, she's there.
You can just tell me.
He wants to do lawyer.
Okay, so Mr. Pena will appoint someone new. If you can come up to the clerk, she'll give you that information.
Excuse you.
Yes, thank you. Mr. Bruce Smith on Fedro Gatlin Lassant. Sorry, I probably should have given you a minute. Good morning. Good morning, sir. Are you Fedro Gatlin Lassant? This is 26 DCCR 0331. Mr. Lassant is charged with aggravated assault causing serious bodily injury. And what is the announcement?
Ashley was telling me this morning that she's requesting a resetting for some additional medical.
Judge, the court allowed us to reset last time, told me to subpoena the medical records. I have received them. I'll get with Mr. Smith's office to get a UBS drive and transfer them for his review. That should determine a restitution amount that will factor into a plea bargain. Otherwise, now that we have those records, we can be ready for trial.
Okay, so we'll just do one reset. It sounds like they're ready. Mr. Gatlin Lassant, make sure you stay in touch with Mr. Smith so that once he gets all those records, you guys can go over those and what your options are. And then we'll get an announcement at the next court date. Thank you. Right. Thank you. You're free to go, sir.
I will email Ken.
Okay.
James McEwen, Mr. Smith. Good morning, sir. Are you James McEwen?
Hi.
And this is 25 DCCR 1186, excuse me. Mr. McEwen is charged with theft of property. And what is the announcement?
Your Honor, I had requested from my client, this is a step-by check, client wrote a check to Phil Pond for transmission. I had requested my client to put together the bank information to show that at the time they wrote the check that he had funds. And this is my first day back. And so I would like to have another reset so I can get with the prosecutor to show him that he did not have the intent to.
Any issue with one reset, Mr. Coleman?
This case should be looked at. I'm okay with reset.
All right, I'll do one reset to give you some time to get that information to Mr. Coleman. Stay in touch with Mr. Smith so that once he gets that information to him, if there's any change in any offer, y'all can visit about that, and then we'll get an announcement at the next court date.
Thank you.
Question.
Mr. Kelly, you've got Ashley Sanders, Ms. Malfino.
She's present, Judge. Let me grab her from outside. Okay.
Lorian. Thank you.
Judge, while she's on her way, may I go off the record on this real fast?
Sure.
Just can't put all that. Gotcha.
All right, you're Ashley Sanders. And Ms. Sanders' case is set for trial next week to begin with jury selection. This is 24 DCCR 1650. Ms. Malfino has let the court know some time ago that she is going to be out of town next week. We kept the cases on the pre-trial docket just to kind of see where everybody is. If it's not going to get worked out today, what I'll do is just put it on the next trial docket. And if anything happens between now and then, please let me know well ahead of that time.
We have been in constant contact on it. I have had a very productive meeting with counsel on this case involving some civil matters, and I think that was very productive. We're very hopefully close to some sort of a resolution, whether it be with regard to restitution, et cetera. Thank you for keeping it on the pretrial. I think that helped move us to this point, but I do feel certain that if it's not disposed of in advance, it would be ready at the next setting, and I will advise said counselor that that is the position of the state.
Okay, perfect. All right, we'll see y'all back at the next court date. Stay in touch with Mr. Kelly. He'll let you know when you need to be back. Mr. Kimler, you've got Wayne Cummings.
Sure. I believe that's supposed to be true.
Good morning, you're Wayne Cummings.
Yes.
And this is 18-29640. There's a motion to revoke probation that's been filed. And what is the announcement?
As the MTRP is based on a new case out of Orange County. Mr. Smith checked last week. It had not yet been filed. So I kind of, other than ask if we could have a recess for that to get done.
Well, that's what we've been resetting for. I mean, the motion was filed of 2025, and we've just been coming back and waiting.
The offense date is October of 25.
Right. And but is there any note on where they are on getting that taken care
I
of?
don't say anything about where it is. Judge just said it has not even.
Okay.
That was, he checked, he called them last week.
All right. So if you'll just make a notation for Mr. Smith to get with them again and find out, I guess, what the holdup is, if they anticipate it being filed and not just whether it has or hasn't, so that we can move forward one way or the other next court date. All right, stay in touch with Mr. Kimler and your bondsman, and they'll let you know when you need to be back, sir. You're free to go.
Good report for probation.
Raphael Glover, Mr. Kimler, and Mr. Nails.
That's mine.
Good morning, sir. You're Raphael Glover, and this is 24 DCCR 0232. Mr. Glover's case is set for trial to be on jury selection next Monday. And what is the announcement?
Your Honor, state has made an offer of probation in this case. Mr. Glover's advised that he's refusing that. The desires to proceed to trial. I'm announcing ready.
All right.
Okay, Your Honor.
All right. So, Mr. Glover, your case is very old and likely to be at the top of the list next week. I do want to make sure you understand that after today, I will not accept any plea agreements. So if you change your mind between now and Monday, you can plea open to the court, but you're not going to come in Monday last minute and think that you're going to get some other deal when we have a jury waiting. So we'll have your case will get numbered tomorrow after the docket. So stay in touch with Mr. Kimler. He'll know that trial order, but I anticipate seeing you Monday at 1. Okay. All right. I'll see you then.
Survives the plea.
Yeah, I'll get to you. I'm just looking real quick. Michael Sarant. This is Ms. Malfino.
I'm Judge, I'm sorry, stuff.
That's okay. I just want to make sure you heard.
I'll take the, sorry,
Good morning, sir. You Michael Eugene Sarant.
Yes, no.
And will your client waive the formal reading of the indictment?
So late.
Mr. Sarant, in cause number 25, DCCR 1691, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from October 16th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimball?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've made is for a 3-year deferred probation. There would be a $500 fine and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Objection.
It's admitted. Any evidence that Mr. Swan is not competent?
There's none there.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll just give me more information about you and your case, and then we'll come back at a later date for sentencing. On your way out of the courtroom today, you need to stop and talk to probation to start that process, and she's sitting at that desk right there. All right, we'll see you back at sentencing. Brian Snipes.
Good. Yes.
Morning, sir. Are you Brian Snipes? And Mr. Snipes, in clause number 24, DCCR 2174, you're charged with the state jail felony offense of theft of mail with identifying information from February 2nd of 2024. Your indictment alleges that you were previously convicted of burglary of a habitation, a second-degree felony, February 18th of 2014. Okay, so it looks like two.
It looks like they're not sequential.
They're not.
Those priors. However, Judge, I do have in my possession a federal judgment that I intend on filing a notice of enhancement for the purposes of the record. It's a.
Just the date of the final conviction.
It's been a while since I looked at it.
February 18th of 2014 is the possession and the burglary, both second degrees.
February 18, 2024.
2014.
2014. Oh, 2014. Okay.
Yeah, Judge, I have a.
What's the date of that one? I'm sorry.
It's a, this one's from 2016. It's a federal possession and distribution of meth, along with a gun charge. The defendant received a 93-month sentence on. My plan is to file a notice of enhancement, including that federal judgment, to get him to the 20 punishment.
Yeah, you'd have to see. I'm not sure if the 2014 conviction was final by the 2016 date, or whether there was an appeal or mandates and all of that. So I would admonish him on a second. He, in any case, he wants a trial.
So I do want to make sure you understand, Mr. Snipes, that if those, the felony conviction that I've read, those two, and the one that Mr. Coleman has in place that he's going to file a notice to enhance, if those are actually sequential, so one was final before the other one was convicted, that means that your punishment would be enhanced to that of a second-degree felony, which is a minimum of 2 years up to 20 years in prison. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Kimler that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 10-year term in prison. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to plead guilty.
Mm-hmm.
Do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get it set on the trial docket. Mr. Kimler will begin preparation for trial. Stay in touch with him, and he'll let you know when you need to be back ready for trial.
Just for clarity purposes, I think in order that 10-year offer to be valid, those would have to be sequenced. I don't
Yes.
think one of them would get him to a third, since they're not a 3G offense. So
It's either a state jail or a
state
second.
jail or second.
Yes.
In the event that those aren't sequenced, then I don't want him to forfeit the opportunity.
No, if there's some issue with the sequence, no, if there's some issue with it, that's why, yeah, I didn't.
I would agree to stay with.
Because they may come back with an offer in the state jail.
Sure.
So, all
That
right.
yes.
Yeah.
Derek Wells, Mr. Kimler.
I'll go get it. Willis. Yes.
Good morning, sir. Are you Derek Wells? And this is cause numbers 26 DCCR 0216 and 0529. Mr. Wells is charged with obstruction or retaliation, as well as driving while intoxicated, third or more. And what is the announcement?
Further state, huh?
Yeah, my understanding is that there is a misdemeanor DWI that is unfiled, is what.
I don't know if it's a misdemeanor, maybe a felony.
That's what Mr. Kimler's representing for me. He just told me that about 5 minutes ago. I'm not sure, but if that's the case, I certainly am not opposed to a reset so that we can run that down.
I've represented that to Mr. Coleman based upon what Mr. Wells informed me. So you have.
What's the offense date?
Yes.
What's the new offense date of the new DWI?
When did you get arrested on the latest DWI?
Exactly.
Well, be as best we can, what month?
I want to say 4 or 5 months after that one over there for today.
This county, is that right?
Yes, sir.
So evidently 4 or 5 months after the one he's indicted on, he was arrested on another one in Jefferson County. And they want to try to confirm that before.
I'm gonna have to confirm, Judge.
Are you still driving, Mr. Wales?
No.
Okay, I'm going to make it today a condition of your bond in the 2 cases that I have that you are not allowed to drive any vehicle, period, ever. The fact that you were on bond for one and got arrested for another gives me a whole lot of concern. So Mr. Coleman will have some time and see where that is in the process. If it's waiting on some kind of labs or things, we'll get that worked out. We'll reset a normal reset. Stay in touch with Mr. Kimbler. He'll let you know when you need to be back. All right, you're free to go.
Thanks, sir.
That's it.
Okay.
See, Mr. Lewis, you've got Devontre Johnson. I reset it.
Okay.
Yeah, that's the MTRP that I reset. Morning. Good morning. Are you Devontre Johnson?
Yes, ma'am.
And this is 25 DCCR 0438. Mr. Johnson is charged with failure to comply with sex offender registration requirements. Mr. Lewis, what is the announcement?
Judge, I think we have a possible resolution with, I've talked to Ms. French this morning. I'm asking if we can have this case reset for next week or for next Monday. So I can meet with Mr. Johnson to thoroughly go over the potential.
Sure. Any issues with a 1 week reset?
I have a vacation letter for next week. I won't be here, but someone will, they could.
You've already made your offer and it's all that's done. Okay, so we'll just do a 1 week reset. Obviously, if he wants to take that, we can get that taken care of. If for some reason not, then we'll get it set on the top of it and do a rejection. All right, thank you. You're free to go. We'll see you next Monday.
Thank you, Mr. Lewis.
Crystal Robinson, Mr. Lewis. Good morning, ma'am.
Good morning.
Are you Crystal Robinson?
Yes, ma'am.
And this is 25 DCCR 1869. Ms. Robinson is charged with deadly conduct, discharging a firearm. And what is the announcement?
Judge, there was some surveillance footage that's available in this case that I need to look at with her. When I talked to Ms. Robinson about it, she had some questions about that footage.
Okay.
So I need to talk, just review it with them.
All right, so Ms. Robinson, I'm going to reset your case, a normal reset, which is about 30 days. You need to make an appointment early, go see Mr. Lewis. Don't wait till the last minute. Right before court, call, make an appointment, go over all of that, look at what he's got, and we'll get an announcement at the next court date. All right, you're free to go. Simranjeet Singh. Good morning. You're Simranjeet Singh.
Yes, ma'am.
And this is 25 DCCR 1870. Mr. Singh is charged with theft of property. And what is the announcement?
Judge, I've talked with Mr. Nichols here, with the state. We've got an offer on this case. I think that will resolve it, but there is an immigration issue. So we can have just a little time for him to confer with immigration attorney before we agree.
Sure.
Agree to it and finalize it.
So I'll do a normal reset. Mr. Singh, you need to make sure, make an appointment, visit with whoever you're going to with regard to any immigration issues before that next court date. Okay. All right. We'll see you back then. You're free to go. Mr. Parker, you've got Maria Lopez or Marie Lopez. Morning.
Morning, Judge. And I need to make ask you to make a correction on the papers.
Okay. Good morning. Are you Marie Lopez?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Sure. On the
Hold on just a second. Let me get it. That's the, right.
Our recommendation, it should be 2/4 because she's not eligible for defer. 2 years probated for 4.
Okay. Any issue with me making that modification on this? All right, Ms. Lopez, in clause number 24, DCCR 0886, you're charged with a state jail felony offense of driving while intoxicated with a child passenger from May 19th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes.
And so also you guys signed those post-conviction waivers at the bottom of the second page. Because there's not an agreement, I'm going to mark those out as well because she's not waiving that right to appeal. So it looks like there's not an agreement. In your case, you're just pleading open to the court, which means you will have some rights to appeal depending on what happens. Do you understand? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? And it looks like you and through your attorney will be requesting that I place you on probation and that the state is asking for a 20-month state jail sentence. Is that your understanding? And what will happen is we'll come back, the probation department will do a pre-sentence report. I'll get more information about you and your case. Then anything that you think is important for me to know, get that information between now and then to Mr. Parker, and he'll present it to me on your behalf when we come back, okay? All right, so I'm going to state tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Lopez is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing, like I said, so we can get that report done. And then we'll come back later for sentencing. On your way out of the courtroom today, you need to stop and talk to the probation officer that's sitting at that desk right behind you, and she'll get that process started. All right?
Just
All right, we'll see you back at sentencing.
okay.
Jorge Quezada.
Okay, that's. I didn't know he was inside.
Good morning, sir. Are you Jorge Quezada?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
No, Your Honor.
Mr. Quezada, in clause number 25, DCCR 1472, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from September 28th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? Are you pleading guilty because you actually did what they charged you with? Spit your gum out in that trash can right over there. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Quezada is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report that'll just give me more information about you and your case, and then we'll come back later for sentencing. You need to stop on your way out of the courtroom today and talk to probation before you leave. She's sitting at that desk right over there. All right, we'll see you back at sentencing.
Judge, I'm sorry to interrupt. Would you mind just please admonishing him as to the no contact being still in effect.
So I do want to make sure you understand, as a condition of your bond, you are to have no contact or communication with Veronica Panilla. You understand? Nothing. Okay, just make